Lordship, in this matter, we are filing one additional affidavit, Lordship. I'm praying for some time, Lordship. I have already informed.
Lordship will recall, my lord,
The records were called for. Have the
Yes,
record
I
come?
have perused the records, Lordship. In fact, I mean,
No, we want to peruse the records. Where are the records?
Lordship, I will definitely place those
You can
records.
place that record, that will do.
No, Lordship will some documents. I think some manuscripts of a video is to be placed, Lordship. That is very vital, Lordship. In fact, Lordship, he has been given opportunity of cross-examination. He declined.
That's what we want to see.
That video, Lordship, manuscript of that video, we want to place, Lordship.
No, it should be there in the records. Whether the records have revealed that.
The video is there,
directed
Lordship.
him to do a recheck if his
Yes,
signatures
no.
appear in the.
No, signature is not the only
Then-
thing, Lordship. Lordship, in fact, that letter we have received, Lordship, by which he was directed to appear before the authority on that particular day for cross-examination. That letter is there.
But where is, was the witness examined in his presence?
Yes, in his presence, he was present, Lordship, from the video itself, Lordship, it appears. And some portion of that video manuscript, Lordship, we want to place. That is very vital for
Okay.
adjudication of this case, Lord.
When can you file it?
Lordship, I'm bringing just 1 week time, Lordship,
But,
because
this court will not be there from 3rd.
then Lordship will keep
30th,
this part heard, Lordship.
30th.
On part heard, Lordship.
Well, it has to remain on 30th.
It will not be possible, Lordship.
The matter was heard Mr. B.D. Goswami, learned counsel for the petitioner, also heard Mr. P.D. Naik, learned additional advocate general, along with Ms.
Cited my
M.D.
friends.
Bora, learned standing counsel, transport department, appearing for the respondents. The matter was fixed today, was heard at length and was heard at some length and was fixed today for production of records to determine as to whether the petitioner was present while the witness was being examined, and also as to whether the petitioner was given an opportunity to cross-examine the departmental witness. Mr. Naik has submitted that the records have been received along with further materials, including a video of the proceedings of the inquiry, wherein the witness was being so examined, wherein the departmental witness was examined, and which would reveal that the petitioner was present and was given an opportunity to cross-examine the witnesses. He submits that he would file an additional affidavit to bring on record the said materials. Prayer accepted. The said additional affidavit be filed on or before. This matter will be taken up after 17th.
1/7, Lordship.
After 1/7, any day.
Well, if they file any affidavit, I will.
Yes, that's why I asked you, when are they filing
In that situation, Lordship will give me some, at least up to
on
4.
till 3,
on
4/8/2026. The petitioner is at liberty to file a rejoinder thereto on or before 14/8/2026. Registered investors matter again on when?
17, Lordship says.
17.
Any
18,
date after 17, Lordship.
18,
Lordship.
18,
Lordship.
18/8/2026.
18.
But the matter will come on 18.
18 for further hearing.
Much of it.
Obliged, sir.
But please, Lord. My lord, I would to mention item number 13, my lord.
Item number?
13. On behalf of my senior Mr. A. Dasgupta, because of this, some personal difficulties, can this matter be taken up on another day?
You are there.
My lord, I have a strong objection, my lord. It's matter pending since 2019 and quite a
What
number of times.
steps have the Arunachal government taken after the materials were forwarded to them? Or is it?
There is
because of
a
the
interim
state
order not to take any coercive action.
action?
The matter is very simple, my lord.
But Mr. Dasgupta is having some problem. What can we do now?
Last chance, my lord.
But, my lord, we have not earlier prayed for any
Last
accommodation.
last
Last
occasion also-
occasion, my lord, the matter did not reach. We were there in the court. On the previous occasion,
Okay.
he could not come.
A prayer is made on behalf of Mr. A. Dasgupta, learned senior counsel, appearing for the petitioner for an adjournment in the matter on account of personal inconvenience. Mr. B.K. Singh, learned standing counsel, FCI, submits that there is urgency in the matter and accordingly a short date be fixed. Also, in view of the submissions of the learned counsel for the parties, registry to list this matter again on
13th of August. my lord.
13/8/2026. No further adjournment shall be granted in the matter.
Obliged, ma'am.
My lord, these matters are for listing, my lord.
All listing matters, give it to a motion.
No, my lord, admission.
So- August first week.
One hearing also, my lord.
He'll give the dates.
Madam,
First week of, huh?
My lord,
Lovely, Samudra? First week of August, so what did you?
my lord, in my case, my lord, I'm praying for listing one IA, my lord. Last time this case was listed on 17, my lord, before your lordship. And your lordship advised me to file IA, my lord, to challenge those two newly, my lord, issued advertisement, my lord. Tomorrow, my lord,
He'll give a date.
my lord, next date is fixed by your lordship on 6/6/8, my lord.
Oh, then
So-
it'll come on 6/8/2026.
So, no, my lord, these two advertisement is
On
is an
3/8/2020.
Monday, my lord, Monday.
Tied up, full tied up this week,
My
next
lord,
week.
my lord, otherwise, my lord, it will be, my lord, no effect will, because, my lord, only,
Yeah,
only
But I
10
said,
days.
yeah.
May I please, your lordships, I beg to mention,
Lordship praying for
I
listing.
beg to mention an IA, that is, we request that be listed with the another WPC, that is in court number 19 tomorrow. That is item number
You make an
57.
application before the authority, before the registry, they'll get it listed.
Because it's tomorrow, that's why we are making
How
it.
can this court, when some other court matter, how can this court require
My lord,
filing of an IA?
it is under bench 3, my lord, that is
Huh. Bench 3, it's listed in court number 19.
19.
So 19, Punasa? You do one thing, you submit an application before the registry, they'll get it listed. If not, any problem, tell him he will do the needful.
Lordship praying for listing in admission matter, Lordship.
Huh?
Admission, for listing and admission next week.
He'll give you a date, give it to him.
My pleasure, also praying for listing a motion matter tomorrow, my lord. My lord, what happened, the one petition came up before this honorable court yesterday, my lord, with regard to the transfer of the petition from Mutali Gang Panchayat to Bamun Gang Panchayat. And there is some error in the petition, lordship. Much.
May I please, your lordship.
Lordship, I beg to mention item number 39. Lordship, we have already circulated adjournment slip. Therefore, we'll request the date in August, any day in August. Lordship.
You are making this prayer on behalf of,
Mr. K. N. Chaudhary, senior.
why, ground?
Lordship, there are several land acquisition matters before DB1 and DB2. Therefore, this case could not be prepared.
A prayer is made on behalf of Mr. J. Patwari, learned counsel for the petitioner for an adjournment in the matter on account of personal inconvenience. Also, prayer accepted. Registry to list this matter again on 10/8/2026.
Lordship, my senior won't be available on 10.
Registry to list this matter again in the, when do you want?
10, 13 and 14, he won't be available any other date.
On 11/8/2026.
Lordship.
You have joined.
Our lordship, some developments are there, but it has become almost infractions.
So sorry,
That
no
is a-
imprimatur was passed.
What is it?
Miss, heard Miss S. Kanungo, learned counsel for the petitioner, also heard Miss K. Kashyap,
AB Kayastha.
A.B. Kayastha, learned counsel appearing for the respondent number 228. Also, Miss Kanungo, on instruction, submit that the petitioner desires not to press the matter any further, and accordingly she prays that she be permitted to withdraw the present writ petition. Also, in view of the submissions of the learned counsel for the petitioner, the present writ petition stands dismissed on withdrawal.
Deeply read.
They had prayed for some,
Lordship, let them bring that, the affidavit on
you have
record.
got an affidavit copy.
I've got it.
What is there?
Nothing, your lordship. What they have done is, whatever I have annexed before your lordship from the writ petition, they have brought all those same
No,
documents by
only
way of
thing
the
is
affidavit.
that your suspension is with the approval, prior or post, whatever it is.
Lordship, the approval is by way of allegedly, the approval has been obtained by the executive council through circulation by email.
Be that as it.
But the what they have actually circulated is not with regard to suspension. What they have circulated is with regard to
Madam, there is a resolution of the, what do you call that, EC, wherein your suspension has been approved, be that as it may. But your case is that the subsequent extensions that have been given,
Lordship.
there is no approval of your appointing authority, that is the DC,
Right, Lordship,
EC.
correct.
So from the perusal of the materials that you have brought on record,
Yes,
it is not clear that there was a approval given for your extensions.
Yes.
It's not evident.
Right.
Now, have they brought on record any material to show that the extensions were being given after the approval of the EC was received?
Lordships, what they have annexed is the same review, DPC, which I have myself annexed. The 181st Executive Council meeting, I have already annexed that.
179, 180.
And 181. 181 is what they have brought on record. The only additional document which they are trying to show before your lordships is that allegedly some review committee had sat beforehand. Now, to discuss about this, whether I should be the memorandum of charges. There is no discussion about the extension of suspension. Even before the Executive Council on the 181st meeting, there is no discussion
No.
about the extension
The
of
second one,
suspension.
second one.
Second one.
Second one, there is.
There is only a discussion about a memorandum of charges has been prepared and we are seeking approval. So in
They
the
refer
order,
to some, there is a reference to some committee. Hey, today, fine, today.
yes, your lordship, there is a reference to that review committee. That
Committee.
review committee is what, because it was not within my knowledge. Now, review committee is what they have brought on record by way of their affidavit.
Where is that? 181, yes.
181. 181 is at page 57. your lordship.
Initial suspension is going to end on so and so, and a review committee has been constituted to review the suspension as per rules. Further charge sheet has been drafted on the basis of and the same is enclosed. Members of the approved the charge sheet and the registrar is authorized to issue charge sheet to so and take necessary action. Now, Mr. Kyle,
Lordship,
okay, you have constituted a review committee.
Lordship.
No issue. Where is the decision of the review committee and where is the approval
If,
given to it?
I have
by
given
the-
requisition to call for the affidavit.
No, where is the approval given to it by the EC?
Yes, Lord.
Just show me, you have copies with you. Give me one.
I have my copy, your lordship. I can just,
Just give me two.
it will be permanent, আপনি?
মারু কিভাবে দেখা আছে?
না, আপনার যেটু affidavit ও,
আমার
মই হেতুই দিয়েছো, আপনার
পেজ
affidavit
পেজ
দিয়েছো।
149
Of the affidavit.
affidavit. It is a notification dated 11/3/2026. The Vice Chancellor is
Page
pleased to
40?
constitute 149.
Okay,
Then
then,
next page is report, Lordship.
this is by a committee.
Lordship.
Now, where is the ratification of this by the executive council?
Lordship.
He is an engineer. No, Prasanto, the-
Oh, by circulation.
Yes, Lordship.
This is by circulation.
Yes.
By circulation. In fact, I am told that there are I have not been able to lay my hands on the particular rules, your lordship. But allegedly, this is not permissible.
Okay, you
Circulation.
get that. You get that.
Lordships, I have not been able to. I've tried my level best, but it
Uh,
doesn't seem to be available. It was just my knowledge.
Get that copy, give it to him. He'll insert.
I've already requested.
Heard Ms. R.S. Chaudhary, Learned Counsel for the petition, also heard Mr. Cal Learned, S.K. Learned, Senior Counsel, assisted by Ms. R. Hussain, Learned Counsel, appearing for the
Only number 2, 3, and 4.
respond number 2, 3, and 4. Also heard Ms. Dr. P. Agarwala, Learned, Standing Counsel, UGC. The respondents number 2, 3, and 4 have brought on record, have filed an affidavit today. So in the said affidavit, it has been projected that the extension of the petitioner's order of suspension, period of suspension, was so recommended by a committee constituted in the matter by the Vice Chancellor of the University. It is further projected that the said that the recommendations of the said committee for extension of the period of suspension of the petitioner was placed before the members of the Executive Council of the University by way of circulation, and the Executive Council members having ratified the having accepted the recommendation of the review committee, comma, the order extending the period of suspension of the petitioner came to be issued. Also, Ms. R.S. Chaudhary has submitted that it is not permissible for the executive council to be meeting of the executive council to be held by way of circulation. Also, Mr. Cal, on the next date of listing, shall place on record the relevant provisions existing which also permit a meeting of the executive council to be held by way of circulation. Also, registry to list this matter again on 5/8/2026. Because we also hold meetings by circulation. But there is a provision in the rules permitting that.
I'll place all this.
There is in our High Court rules, there is a provision. If there is a provision, this is permissible.
Lordships, I have other submissions which perhaps.
No, we'll just go to the root of the matter.
Lots.
Definitely. And in the meanwhile, I'll file my reply.
Huh?
In the meanwhile, I'll file my reply as well.
Ms. Chaudhary is at liberty. The petitioner is at liberty to file a rejoinder to the affidavit filed by the respondents, comma, ipso advised, comma, before the next date of listing.
Much.
Deeply obliged.
Please, Your Lordship, item number 4, the matter may be taken up on Monday. Due to some personal difficulty, he is unable to.
On the prayer made by Mr.
on behalf
PD
of-
Nair for an adjournment in the matter on account of person inconvenience. He's not here.
He has a video consultation with a doctor for that.
Huh?
He has a video consultation with a doctor.
Doctor, personal inconvenience, an accommodation in the matter. Okay, Lisa. On the prayer is made on behalf of Mr. PD Nair, learned senior counsel for the petitioner for an accommodation in the matter on account of personal inconvenience. Also, prayer is not objected to by Mr. S. Das, learned. CGC.
No, my lord, I'm appearing on behalf of K. Gugoi, my lord.
Prayer
State
is not
Bank.
made on, prayer is not objected to by the learned counsel appearing for the respondents. So in view of the above, registry to, when will he be there available in the first and second week?
The matter will be taken on Monday,
Monday, it's not possible. This week, next week, not possible.
on 5th of August,
On 6/8, okay?
6th of August.
6/8/2026.
Lordship, he will not be able to, and. I guess
4th?
5th. No, he will be out of station,
5,
5th of August.
5/8/2026. So the matter be not treated as parted and tied up matter with dispense any further.
Highly honored.
Yes, Mr. Chaudhary.
Also, in the affidavit, we have clarified the reason for which.
So there is no termination order issued in favor or in respect of the petitioner. It's only a desertion order.
Yes.
So if it is only a desertion order, a termination does not occasion. His termination had not occasioned. If that has not occasioned, he having died before you could take a final decision in the matter, the whole period will now have to be regularized because you have not assessed as to why, whether he was prevented from reasonable grounds from appearing.
No, Lordship, in paragraph number 8,
Hmm.
so Lordship kindly see. Paragraph number 6.
6 or 8?
6.
No, this is only with regard to a decision for
Exactly.
declaring him deserter.
Desert.
That's all.
Yes,
Not for the
And-
purpose of dismissing him.
exactly.
You have not drawn up a departmental proceeding
And
against him.
we have relied on the provisions of the CCS rules and that has been
5 years.
reflected.
5
yes.
years.
54, Lordship kindly see paragraph number 12, page number 6. Just third line from bottom. The individual died while on desertion period on 31/3/2009 and was not on the active strength of the unit. Hence, the petitioner is not entitled to get the.
But he cannot be cut off from the active strength. This year's pension rules.
CCS pension rules 1970, 54. Court of inquiry was conducted and accordingly his name was struck off from the unit strength, Lordship. We have specified.
Where is the charge sheet then? Where is the charge sheet issued to him? Have you said anything about that?
We have made a mention with regard to that in paragraph 6 only. So the petitioner wife of the individual also did not respond to the apprehension roll sent to her by.
Fine, forget
Yes.
the wife. It's a person whom you have to catch.
Therefore, a court of inquiry under section 106 of the Army Act
Court
was.
of inquiry is for declaring him
Exactly.
deserter. That's
Exactly.
all.
And subsequently, his name was struck off from the unit strength. That is the point we have raised in our affidavit in opposition.
Okay, how is 54 applicable to his case? How is 54 being applied?
No, we have made a mention that the family pension is entitled to the family of the government servant who dies while in service or after retirement. So we are saying that since his name has been.
In service, he has to be deemed to be in service. This is only a fact you have that he was unauthorizedly absent. That was not subsequently proved, established by way of holding an inquiry.
No, to some extent we have done it, Lordship, in paragraph 6.
Where
In
is
paragraph,
Sokos?
yes. With regard to
Sokos.
that, then I have to.
No,
take the
forget, we are
record.
not giving you even a.
No, the
time. We
thing
are
is that in
only-
paragraph 6, the reflection is there, Lordship. This,
Show me.
Lordship, kindly see therefore, the court of inquiry under section.
Court of inquiry,
Exactly.
Mr. Chaudhary,
Yes.
show me that it is the final thing. Show me. That it is the final thing, I'll dismiss the petition.
Because when his name was struck off from the unit strength.
It was not struck off, it was kept in abeyance. Show me where you have written that it is stuck off.
Lordship, kindly see in this particular affidavit, this page, paragraph number 6. From bottom, it is the fourth line, Lordship. Accordingly, he was declared a deserter and his name was struck off from the unit strength.
Then read further.
From the unit strength, however, he was kept on supernumerary strength for 5 years as per the policy. As keeps, yes.
So he continued to be a
Exactly.
member of the force then.
Yes.
So give the lady everything, whatever she is entitled to now. You have not determined the reason for the absence. You have only noted the absence.
The technical flaw.
Naturally,
Yes,
if you have the wherewithal to hold the inquiry against him, now hold it.
Yes.
Send somebody up, get it done, come back.
Yes. Yes.
Again,
That's
you can do it. Then do it. How long will it take? How long will you take for completion of that inquiry? Because whether you'll have to find out where he is first, whether he is in heaven or some other place.
No,
Okay.
it is otherwise impossible.
But Miss-
Including compassionate appointment, my lord, because they have processed her case and they have stated that
Okay,
you apply as and
Okay.
when, my lord.
okay. Argue.
I'm not arguing, my lord.
Argue.
I'm praying, my lord.
Arre, satisfy me.
I'm not arguing. my lord,
Arre, for
because,
praying, you will have to have material.
My lord, I have one judgment from Madhya Pradesh High Court.
Give me.
Yes, my lord. Dear, my lord. Paragraph 13, my lord.
And there is no paragraph 13 here.
It's there, my lord. The small number is there, my lord. Lordship will see.
This
At
judgment is of 11 paragraph.
Page 4, my lord. Page 4. Number is bottom, my lord. This is a date case, my lord.
We are rejecting your prayer.
My lord.
Your husband died on which date?
My lord. 31/3/2009.
Huh?
31/3/2009.
9.
Death certificate.
What is the date today?
My lord.
You want pension?
My lord, yes, sir. Service benefit, my lord.
That much you will get.
Including my lord, because CC paid for the appointment, my lord.
Hmm.
And lordship will see there, they have written that we applied when the vacancy arises. My lord. Lordship will see, my lord. They have already written, my lord. If they consider, lordship will be pleased to send them
We
for
will not
consideration. my lord.
even give you that liberty.
Because let them consider, my
Second
lord.
opportunity.
My lord, let them consider, my lord.
They will not.
That too, Lordship.
That too.
Obliged.
I'm seeking a time being, my lord. Mr. K. Gogoi is held up in another court.
Yes, Mr. You, yes.
My lord, to pursue your lordships, my lord, I am referring a decision of the apex court. Paragraph 9, my lord, exactly what your lordships wanted.
Yes.
Another decision in the line of this, my lord, by the recent decision of this honorable court.
My Lord Justice Michael's decision, no.
No, Justice Kaushik. Kaushik Goswami. 680. My lord, in paragraph 12, your lordship kindly. Lord, the upshot of these decisions, my lord, the punishment can be imposed on a serving official on.
Now, okay, we interfere with that. What would be the consequence?
Consequent will be that he is entitled to get the entire thing, my lord, if there is no punishment.
No, because this penalty that has been imposed, you have not assailed it also. Now, how can we leave them without a way out? They can take a call with regard to your pension. You're in a pensionable.
Yes.
So they can take a call with regard to that, withholding, withdrawing, whatever they want to do. We'll have to give them that liberty,
Lord,
subject to what Mr.
I could not get you, Lord.
The penalty that would now be permissible, this penalty is not permissible. But a penalty has to be given to you. We can't exonerate you in these circumstances. So we'll have to remand back the matter to the university authorities to take a call with regard to the penalty that would now be permissible under the pension regulations. Whether a deduction in the pension or withholding or not, nothing, whatever it is.
To that extent.
To that extent only. Yes, Mr.
To that extent, I have no difficulties, Lucy. Otherwise, he is getting the pension also, Lucy.
No, because if we have to interfere with this.
That part is the otherwise, I have no, getting that view, Lordship, I have no any objection, Lordship. There, for a moment, just I rely paragraph 130, page 132, Lordship. I am not relying any judgment, Lordship. Page 132 of the repetition, Lordship. Paragraph 30 and 31, Lordship. It's a Lordship way. On the basis of the two page, it's a continuous process, Lordship. Paragraph 30 and 31, Lordship.
No, it cannot be when did you retire, Mr.
My lord, 1/5/2009.
And that particular judgment was delivered by the Honorable Court on 2015, Lordship. That was not pointed out before the Honorable Court, Lordship. It was not pointed out
What
before
do
the
you say
Honorable.
on this?
My lord,
That
the
does not-
judgment was set aside.
No,
No, no.
this judgment is of 2015
15, Lordship.
Yes.
and the matter was remanded back.
Lordship. And on the basis of that, we have acted upon,
There
Lordship.
were total, my lord, 5 cases
We
possible.
have acted upon on the.
All the matters were remanded back.
And the first penalty after the order is at page 150.
Yes, 150.
That is withholding of compulsory retirement.
Compulsory.
Compulsory time. From the date, Lordship, 31/12/2004. Now it was rectified, Lordship, from the date of superannuation, Lordship.
My lord, my argument was on merit that, my lord, if we forget this chapter also, now then the similarly situated person, he was imposed a punishment of stoppage of one increment.
This modification is also wrong. Your modification is also wrong.
Modification part probably in the Lordship.
It is there. It is from 1/10/11/2016. Clear non-application
Yes.
of mine.
They also, it's go from Lordship 9. It should be from 9, Lordship. It should be from 9, Lordship. Yes, because Lordship, the order was passed on 2015.
Is there a provision in your rules permitting withholding of pension or pensionary part of pension or something like that?
That part is there, but he is getting the pension, Lordship. It is the reason.
You can still stop it. We will permit you.
Lordship may pass order, Lordship. I have no
You
difficulty.
take a call, but it should be maintaining parity with the penalty imposed upon that other person. What is his name?
He is, my lord,
PK is probably, Lordship.
That controller.
Controller.
controller, yes. Datta, some Datta, my lord.
S. Datta, Lordship. Oh, sorry.
Yes, Datta Moy.
No. Apuni aru eta kiyo S. Datta ta yato.
Kamaleshwar.
K. Datta.
Kamaleshwar Datta, Lordship. Kamaleshwar Datta.
The PW2, my lord.
Otherwise, Lordship, the authority of the university has done on the basis of the direction by my lord direction. We have acted upon.
No, we got it, but we did not say that you act in derogation of law. This court never said act in derogation of law. Merely by this court remanding the matter, you can't act in derogation of law. Where is that provision with regard to withholding of pension?
Dear Lordship, I have not pinged that.
Can you give me that extract of that at least?
By tomorrow, Lordship, I can.
Tomorrow.
Tomorrow, I can. Tomorrow, even Lordship, I can give whole egg, I can.
You can give the whole deck, you give the whole deck, we'll pass the orders on Monday.
Lordship.
My judgment was otherwise ready.
Lordship. Even Lordship, that was ready before vacation, Lordship.
Okay, fine.
Even, my lord, I'm agreeable to that also.
Huh?
I'm agreeable to that
What?
judgment. The judgment which you are.
No, I can't pass this order now. Once I have.
On the face of this.
Yes, how can I give you benefit till 2016? How can it be?
No, that of course, your lordship cannot.
That is exactly what I have done.
Yes.
Now
That
this
is a
is gone, we
fault
can
of the lordship.
disclose. The penalty, earlier penalty of so-and-so imposed upon the petitioner having been interfered with so-and-so and by also remanding back the matter so-and-so for a decision to be only in the event the petitioner is deemed to have continued in his services with effect from so-and-so, the petitioner shall be deemed. I had remanded back with regard to giving you the penalty by maintaining parity with Kamaleshwar Datta.
Yes.
So I had remanded. Then I was just looking, then I got to know.
Ace pectoral is come.
But I really skipped that part, my lord. I am grateful to your lordships.
Okay.
Lordship.
Third day, the Learned Council for the parties at some length. Hearing remains inconclusive. I'm just putting it like
Lordship.
registered to list this matter again on Monday for further hearing.
My lord,
Just give,
Lordship, instead of
you need
Monday-
not be
Monday-
here. You need not
Lordship,
be.
instead
can it
of
be Tuesday?
Tuesday.
Tuesday, Lordship, I have also difficulty Monday, Lordship.
Tuesday. Date to DDB.
Monday,
Etu,
Shillong.
file to move DP.
Lordship, in respect to item number 4, Lordship, I was another.
My lord, in regard to,
We have recorded your name.
Yes, sir.
Respondent K. Gugoi, item number 4. Mr. K. Gugoi, huh?
For the
Has
bank,
no
Lordship.
objection.
Lordship.
my lord, so far, my lord, the
Oh, eight.
ordinance 2000.
Huh?
The ordinance 2000 that speaks you can punish a person who is the employee of the organization. My lord, it is at par with this bank regulation also.
If you have, just give it.
Yes. That clause 28, your lordship will find. it.
US regulation, this is, sir.
One be not over.
At page 10, 8, your lordship will find that. Compulsory retirement 28, an employee in the top, my lord. Can punish so long, my lord, employer-employee relation exists.
But when I told you this point at the first instance, you did not take it very easily.
In fact, I
Well-
could not understand.
Well, Lordship, we have acted upon the Lordship's order. Yes, dear Lordship.
And
Oblige.
Okay, Mr.
The junior counsel who assisted me on that day, he also did not inform me. So your query was that.
It's okay, Mr.
Obliged.
Oblige.
We are here to do justice, not to follow the.
Lordship.
But we have learned a new point.
No. I missed it.
We missed it, Lordship, because our duty was to point out it, Lordship.
It's
Oblige,
okay.
Oblige, Lordship.
Oblige.
Everything is fine which ends well. No, all is well that ends well.
Yes, ultimately.
Oblige.
that.
Mr. Bora, you are continuing till now? Who is opposing you? Huh?
We have filed a affidavit over.
What is there?
Lordship, Lordship, this is a hospital, Lordship.
Be that as it may,
Lordship-
any incident after the order passed by this court?
Lordship, there was there was a termination order, Lordship. That was, Lordship, here we have already stated that even now there's instances of misbehavior from.
Where?
No,
What steps have you taken?
No, Lordship, the termination order had been stayed. So now we are not in a position to take any steps.
Who said if there is a fresh misconduct, you take steps?
Lordship, because of the pendency of the senior officers, they're not taking a decision because.
Okay, what we do is we make that order absolute with giving you liberty that in the event of any misconduct or any other aspect which may permit termination of the services of the petitioner, you are at liberty to take some steps.
Yes, Lordship.
Is that-
Yes, Lordship, because they are complaining.
Because now my Mr. Chalia,
Lordship.
the order was stayed on the ground that she was not given a hearing.
She was a contractual employee.
Be that as it,
Yes.
that's the tenure of the order.
So
This order
before
was
reply-
passed
Yes.
on 11/4/2018, around about more than 8 years.
Yes, Lordship, because of the pendency, Lordship, we have not taken any steps.
8 years ago. You have not filed in your affidavit, have you brought on record any instance
Yes,
after
yes,
the, show me.
No, after, not after, because.
That's
Lordship,
what I'm saying.
No.
After the thing, whether there was any instance of any misdemeanor on a part.
Lordship, regarding that, I'll take a specific, because we have been told recently also, now also it's ongoing, the behavior, Lordship. Here, Lordship, the case is, Lordship, this is a institute, Lordship, medical institute. Here we have seriously that this person is causing harm by her behavior, and the patients and the other officers, also senior officers are also being.
Hurt Mr. Bora, B. Bora, BP Bora, Learned Counsel for the petition. Also heard Mr. A. Cholia, Learned Standing Counsel, Health and Family Welfare Department. Mr. Cholia submits that the petitioner, in view of the fact that there was an interim order operating in the matter, was not in view of the interim order operating in the matter, staying the effect of the order of termination issued in her case, staying the order of termination of her services, comma, the subsequent misdemeanors and subsequent misbehavior, unruly behavior, as well as causing disturbance to the smooth functioning of the institution, comma, were not taken up against the petitioner. So he submits that, oh, we give you liberty.
Yes,
You take steps, we'll
Yes, Lordship.
allow this writ petition. You take steps.
Yes, Lordship, if there is any
Lordship
future.
will kindly have a look at that impugn order, Lordship, nothing is there, and in the affidavit.
Oh, but if your continuous behavior is
No,
that,
no,
Mr.
absolutely
Bora,
not, absolutely not, Lordship. I am appointed in 1999. The first incident happened in 2007, 17.
Okay.
Just
how old is the lady?
Just because I filed an RT.
How old is the lady?
52 around.
You mind your own businesses.
Yes.
Go ahead, work, get your salaries, forget the rest, what is happening in the world. You act within the confines of your jurisdiction. Don't try to go beyond that. If you go beyond that, this is the consequence that you will face.
That is all, Lordship. We want the institute to run peacefully,
Okay.
Lordship. That is all.
Mr. Lihisa, BP Bora, so and so, and Mr. H. Alia. The petitioner in the present writ petition has presented a challenge to an order dated, have your seats, 21/2/2018, by which the contractual services of the petitioner was discontinued with immediate effect and until further orders. Also, as projected in the writ petition, the petitioner was in pursuance to a process of selection appointed on contractual basis vide an order dated 28/5/1999 as a receptionist under the district mental health program, comma, a program introduced by the Ministry of Health and Family Welfare. The petitioner was so appointed in the district of Nagaon. So, while the petitioner was continuing with her such services, comma, and again, as the said program was being continued with, comma, the services of the petitioner was also being so extended. So, thereafter, vide an order dated 21/2/2018, comma, the Joint Director of Health Services, Nagaon, in terms of a direction issued in this connection by the Director of Health Services, Assam, proceeded vide an order dated 21/2/2018 to discontinue the services of the petitioner. So, being aggrieved, the petitioner had instituted the present writ petition. Mr. BP Bora, Learned Counsel for the petitioner, after reiterating the above facts noticed herein above, has submitted that the program is still in continuation, program is still in existence, and accordingly, the services of the petitioner being coterminous with the said scheme, comma, her services were required to be so continued with. Mr. Bora submits that in the order in the order dated 21/2/2018, discontinuing her services, no reasons have been set out. So he submits that before issuance of the order of discontinuation of her services, no notice was issued to the petitioner, bringing to informing her about any misconduct committed by her and or that her services were not up to the mark, were not satisfactory. So Mr. Bora has submitted that for the first time, the respondents in the affidavit filed in the matter had brought on record that the petitioner's behavior in the establishment was not one which is so mandated from a employee who is employed in a government institution and a program. He submits that it is projected that the petitioner used to quarrel with her colleagues as well as misbehave with the senior officers. It is projected that the conduct of the petitioner had the effect of disrupting the medical services rendered in the institution wherein the district mental health program was being implemented. He also has projected that Mr. Bora submits that the allegations now leveled against the petitioner reveal a commission of misconduct by her, and accordingly, in the event the petitioner was required to be terminated from her services, an inquiry in the matter involving the petitioner was mandated to be so held. He submits that given the background leading to the order issuance, given the background leading to the issuance of the order dated 21/2/2018, he submits that the termination of the services of the petitioner was clearly stigmatic. Accordingly, he submits that the said order of termination of the petitioner would mandate an interference from this court. Per contra, Mr. A. Cholia, by taking this court through the reasons adduced in the affidavit filed in the matter by the respondents, leading to the issuance of the order dated 11.
Lordship,
21/2/2018.
page 56 of our reply, there are allegations that we have asked her to furnish a reply where she has not cooperated also in page 56 of our reply, Lordship. Lordship, may
Submit that the behavior of the petitioner during the period she had discharged her duties, had the effect of disrupting the activities of the institution wherein the mental health program was being so implemented. He submits that reports in this connection being placed before the Director Health Services, Assam, it was required that the services of the petitioner be discontinued in the interest of the personnel and patients of the institution wherein the district mental health program was being so applied. So, Mr. Cholia, on instructions, has further submitted that after the order of termination of the or discontinuation of services of the petitioner was stayed by this court via an order dated 11/4/2018, the petitioner has continued to demonstrate such unruly behavior in the institution and is again disturbing the smooth conduct of the patient care being provided in this said institution wherein the district mental health program is now being implemented. He submits that because of the interim orders continuing in the existence of the interim orders passed in the present proceedings, the respondent authorities have not taken any step against the have not taken any action against the petitioner. So I've heard the learned counsel for the parties and also perused the materials available on record. Although in the order dated 21/2/2018, no reason has been assigned for the discontinuation of the contractual services of the petitioner, a perusal of the affidavit filed in the matter by the respondents would go to reveal that the petitioner was alleged to have hindered with the healthcare services provided to mentally ill persons in the institution wherein she is presently working as a receptionist. Institution wherein the district mental health program is being implemented and the petitioner is working as a receptionist. So the petitioner is alleged to have demonstrated unruly behavior to her colleagues as well as patients and also misbehaving with the authorities of the said institution. It is also projected that police cases were also registered by the colleagues of the petitioner against the petition by the colleagues of the petitioner alleging therein that the petitioner had physically assaulted them. It is also seen that the petitioner was issued with show cause notices with regard to the misbehavior committed by her to her controlling officer. So, on a reading of the affidavit, this court finds that the actual reason behind the issuance of the order dated 21/2/2018 is the misconduct committed by the petitioner during her service as a receptionist under the mental health program being implemented in Nagaon. So this court does not find that the petitioner was given any notice wherein such misconduct committed by her was put up, requiring her to reply the same. The only show cause notice found in the found in the records is one issued to the petitioner alleging commission of misbehavior by her with her controlling officer. However, the same is also not found to have been taken to its logical conclusion. So it is for the above reason, the impugned order dated 21/2/2018 admittedly is innocuous, and the same not being preceded by an intimation given to the petitioner about a discontinuation of her services, this court, while issuing notices in the matter, was pleased had proceeded while order dated 11/4/2018 to keep the said order in abeyance. The said order dated 21/2/2018 in abeyance. The said order was thereafter continued with. The respondents have not filed any interlocutory application praying for vacation of the said order, although it is the instruction received by Mr. A. Cholia that the petitioner has continued to demonstrate such unruly behavior in the said institution. So, in view of the above discussion and it not being brought on record that the petitioner, after the passing of the interim orders, had again resorted to unruly behavior, which has the effect of hindering the functioning of the institution wherein the petitioner is working as a receptionist in connection with the district mental health program, this court is of the considered view that the interim orders passed in the present proceedings must be made absolute. Accordingly, the impugned communication dated 21/2/2018 stands set aside. Although this court has next interfered with the order dated 21/2/2018, a communication dated 21/2/2018, and thereby permitted the continuation of the petitioner in her contractual services. This court grants liberty to the respondent authorities to proceed against the petitioner in the event any commission of misconduct is reported against her after following the due process of law. The respondent authorities are also at liberty to evaluate the services rendered by the petitioner, and in the event it is found that such services being rendered by the petitioner are not satisfactory, the respondents would be at liberty to take such steps in connection with the services of the petitioner in accordance with her order of appointment, provided there is no allegation of misconduct leveled against the petitioner in such circumstances. With the above observations and directions, the present writ petition stands disposed of. We can't let you go, but we will permit you to continue.
Please, your lordship, the Honorable directed to file the affidavit, my lord. My affidavit is ready, but due to some urgency, my lord, on behalf of the concerned branch, my lord. For some time to covering letter is that is I didn't file, my lord, till now, my lord, because of some emergency in service, my lord, that they could not put their signature, my lord, in the affidavit, my lord.
Why?
My lord, there is some, they have written one letter to me, my lord. That is the covering letter of my affidavit in operation, my lord.
That does not say.
Does not say anything, my lord, but there is some emergency that which I cannot, I am not permitted to place before the court, my lord. There is an emergency in service, my lord. That's why, my lord. So, though they are asking for 4 weeks time, my lord, within a week I'll file, my lord. Affidavit I have already sent for vetting and for
Heard Mr. M. Beria, learned counsel for the petitioner. Last chance.
Last chance, yes, my lord.
Also heard Ms. A. Gain, learned counsel, learned CGC appearing for the respondent. Ms. Gain submits that the affidavit in the matter is ready. However, the person authorized to sign the said affidavit was not in a position to append his signatures to swear the said affidavit in view of a service emergency arising in the matter. She submits that the affidavit would be filed on or before
31st, 31st of July, my lord.
31st July 2026. You'll find a reply. The petitioner is granted time till 14/8/2026 to file his rejoinder thereto. No further time shall be granted to either of the parties for bringing on record any further pleading. Registry to list this matter again on 28/2026 for further hearing. Will not give you any further.
Yes, my lord.
It will take.
My lord, instead of 31st, can it be, my lord, 5th of August, my lord? Because if they require some more time, my lord, 5th of August, my
I
lord.
can give you till 3rd of August.
Yes, my lord.
Because
Yes,
I'll
yes,
have to give him some time to.
yes, yes, my 3rd of August. Must oblige, my lord. Must oblige. Good night.
Yes.
My lord, long pending case, my lord, the petitioner under suspension, my lord, and he is not on duty, my lord.
Long pending case. Last time you were not prepared.
Yes, my lord. That is why
So,
I
no,
admit my.
you make a submission that we are not this. So last time I have recorded in the.
Yes, my lord. I am admitting that that is fault from the petitioner side, my lord. Not blaming the court, my lord.
Mr. Sigdar was ready. The other parties were ready. You
Yes,
were
my lord.
not ready.
Yes, my lord.
Yes. What is your case?
Case, my lord, petitioner was appointed on 14/6/2011, my lord.
Cooperative
As
society.
secretary.
Where is the resolution or your order?
Order, my lord, page 13, my lord.
তোৰ কিয় মাৰিব লগা আছে নেকি? মাৰিব বাকী আছে নেকি?
And he resumed his office, and subsequently, my lord, some allegation was alleged against him, and he was some cases were instituted, complaint cases also filed. And challenging those allegations, the petitioner approached before this honorable court by filing a writ petition. That is, my lord, page 15, my lord. High Court order, my lord. Operating part, my lord, page 17, that was disposed of with the direction that last para, my lord.
Yes.
My lord, subsequently he approached before the Department Register of Cooperative Societies for appeal, and that was also decided. That is, my lord, page 18. Operating part, my lord, page 20, my lord. In view of the above, I am of the opinion that the removal of the petitioner Sri Topazul Hussain from the post of Secretary of Nambarpata Sakla SS Limited, North Shalmara, Obhaipuri, is contrary to the provision of law. Hence, I, Sri S.K. Gogoi, IAS, Register of Cooperative Societies, Assam, as empowered under Section so-and-so, Assam Cooperative Societies. And subsequently, my lord, an inquiry was conducted against those allegations. And that inquiry report, my lord, annexure 4, page 23. Onwards. And finally, my lord, page 27 and 28. Page 27, my lord, column 6. Though the secretary was a non-government one and
Okay, then what happened finally?
finally, my lord, subsequently, one after another allegation was instituted against him, and one after another, it is the fourth time petitioner before this honorable court. And lastly, they filed criminal case, and the trial is going on, about to finality, attain finality. And
No, what is your grievance in this case?
grievance, my lord, by passing an order, that is, my lord, annexure 14, page 66, my lord. By this order, my lord, he was removed from the service, and his
Read that
my lord.
third paragraph.
Yes, my lord. The Register of Cooperative Societies Assam White Letter so dated 5/3/18 issued instruction to the society who is the employer of MDT Hussain to take action as per section so to for removal of him. But MD Hussain challenged the order dated so and consequential dismissal resolution of the society passed on so before the Honorable Gauhati High Court. The Honorable Gauhati High Court issued direction to the statutory authority.
Where is this order? 19/3, 2000, 5/3, 2018.
5/3, 2018, page 36, my lord.
No, where is the order passed by this court after challenging 5/3 and 19/3? Page 49.
Page 49.
Then what happened?
Again, my lord, against that, the society took some resolution and filed criminal case, my lord.
Why is this order bad?
My lord.
Why is this order bad?
My lord, from the inquiry report, which was conducted, that is, my lord, page 23, last page, my lord, 35. It is, my lord, page 27. The allegations are not proved, my lord. But one after another, the society lodging FIRs, taking resolution, and ultimately, my lord, he was driven out from the office.
Where is the inquiry under 38(2? That was the action under 38(2 in pursuance to page 36?
36, my lord. That is, my lord, it was subdivisional magistrate, my lord, I see that is 39, my lord.
Page 23, who has given this report?
23, it is filed by the ARCS, National Register of Cooperative Societies, my lord.
Thereafter, there was further allegations against you,
My lord.
which led to the passing of page 36.
Yes, my lord.
Huh?
My lord.
Then where is the proceeding under 38.2 that was taken up?
It is, my lord, page 39. Subsequently, on that basis, my lord, one executive meeting was sitting, page 41, annex 7, my lord. And in that meeting, my lord, it was unanimously decided to dismiss the secretary, my lord. Page 42. Resolution 1.
Okay. Then what happened?
Against that, my lord, against that proceeding, he approached before this honorable court.
This honorable court remanded back you back to the
My lord.
register.
My lord.
And the register where is the order of the register just now you showed me?
My lord, page 11, my lord.
No, 66.
Yes, my lord.
It approved the resolution of the managing committee. You say that this approval is perverse because there was no material found against you in the magisterial inquiry.
My lord.
And the executive committee had not, management committee had not conducted any inquiry in the matter. That's your case. Yes, Mr. Sikta.
My lord, my friend has referred the inquiry report. Lordship may kindly have a look at the last page of the inquiry report, page 28. The inquiry report goes to show that there was no proper submission of the records. The veracity of the allegation will be learned only after departmental audit. They have not conducted any audit.
Okay. Now,
then,
who are you? Who are you, Mr. Sikta?
I am the
Society.
I am the society chairman and the secretary also.
Okay.
The
Now,
secretary.
you just come to the resolution of the society.
My lord, the facts behind is that after the first resolution terminating him challenged by the petitioner, that was
set aside.
Set aside, and he was reinstated. After he came into office in the second time, he committed some more corruptions, and he has not conducted audit. He has not. He kept the money
shall proceed in his own pocket. This type of allegation was lost again. And
These are allegations against the petitioner.
yes, my lord.
Now,
And-
if these are allegations against the petitioner, what is the basis for the managing committee to arrive at its decision at page 41, 42, and 43?
My lord. My lord, this proceeding in page 41.
You have the latest current Property Societies Act 38(2).
I have 7, my lord.
My lord, before that, my lord, I want to refer the order of the inquiry register earlier. The 2 officers were appointed. Lordship may kindly have a look at, my lord, in our affidavit in opposition. Page 15. Page 15. Page 15, the 2 officers were appointed for conducting the inquiry. The Sofikuddin Ahmed and Baneshwar Terang. And the officers shall submit their report within 10 days from the date of this issue of this order. In the interim, it is ordered that during the pendency of the inquiry, the Tafasal Hussain shall not be allowed to function as the secretary of the Nambarpara Sakla SS Limited, and the BOD of the secretary shall make suitable temporary arrangement for handing over the charge of the secretary as per provision of the. Then, my lord, this inquiry, and after the inquiry, this order, my lord, in the writ petition at page 36, they have annexed, and I have annexed in, my lord, in page 70 to my affidavit.
17.
17.
Where is the report?
This is the ultimately order of this registrar based on the inquiry report.
Okay, the inquiry reports are available in the
Yes.
writ petition.
Yes, ma'am.
The first is page 39, magisterial inquiry.
My
Now come to the findings at page 40.
Page 40. My lord, this was the earlier. This was the earlier event. They have wrongly relying on this. This was the earlier. This has gone. As per the order of this honorable court, he was reinstated. We have allowed to resume his office. But after that, there has been subsequent allegation. And there was.
Where is that report of the committee?
The inquiry was the inquiry, my lord, which was conducted by Sofikuddin and Terang. That was that was ultimately, my lord, reflected in the order in 5/3/2018.
Where is that report, Mr. Ahmed? This report is there. It is available at page 23.
Yes. Last page of that, my lord, at page 28. Then, my lord, the inquiry report is submitted to the registrar, and the registrar passed this order at page 36 of the writ petition. And the registrar has concluded finding under paragraph 4, the last paragraph, the allegation that the secretary and the acted whimsically superseding the BOD was found correct. Further, another ministerial inquiry was conducted in the same set of grievance by Srimati Mitali Lahakar, ACS Executive Magistrate, which was forwarded by the SDO Civil by so-and-so. You are hereby asked to take action. Action as per section 38(2) of the Assam Cooperative Society Act 2007 and bylaws of the society. This was the instruction, my lord, given ultimately to this society, my lord, the chairman of the society, that the society may take action under.
Now come to page 24. One of the allegations in page 36 noted by the registrar at page 36.
My lord.
That letter which requires him to take action under 38(2).
My lord.
One of the allegation is that the petitioner had collected a total of 2,20,000 from 10 shopkeepers. Now you see the finding at page 24.
My lord. It is true that an amount of 22,000 from each of the 10 persons totaling so-and-so in the name of the constructed 10 rooms for them on so-and-so under pattern. In the investigation, we found that 10 rooms were constructed with this amount of money. On so-and-so, Akbar Ali, the president of Market Management Committee, informed the Assistant Registrar Cooperative Society of every in writing. Hence, the allegation that the secretary misappropriated the entire amount of rupees 2,20,000 is not true. My lord, this is one part allegation, but ultimately, kindly see, my lord, the conclusion, the last observation of the inquiry is put. The allegation, they could not ascertain. The entire veracity could not be ascertained because there was no departmental audit in the page 28, my lord. Last observation is very important, my lord. Page 28. The veracity of the allegation will be learned only after departmental audit.
Okay, where is the departmental audit done before the registrar or the committee had taken a call?
My lord, the order of the registrar, page 36 of the writ petition, it is the finding of the registrar that the allegations are correct. Not on one allegation. There are so many allegations.
No, that he has set out. He has set out therein.
My lord, and therefore the registrar has allowed us, permitted us to take action under section 38(2).
Yes, Mr. Talda.
My lord, the order at page 66, my lord, is under challenge. And the registrar, my lord, has assigned reason why, my lord, he has been not allowed to work. My lord, I am reading it out. Peruse the order of the Honorable High Court dated.
No, you can. We have been taken through that. You can come straight to the fifth paragraph. 1, 2, 3, 4, fifth paragraph.
Yes.
Examine.
Yes. Examine all the relevant books and records, written statement of the parties concerned. It appears from the records that there are criminal cases against Mohammad Hussain in regard to misappropriation of fund of the society. The normal activities of society has been affected due to the criminal activities of the secretary of Mr. T. Hussain, that is the petitioner. This matter is now under the disposal of the Honorable Subdivisional Judicial Magistrate, North Salmara, Abhayapuri. The statutory audit of the society is hampered due to the activities of Mohammad Hussain. In view of above, it is opined that Mohammad Hussain is allowed to continue in the post of secretary of so-and-so society. The entire process of inquiry and audit conducted by the Registrar of Society, Assam, as per the decision of the Honorable Petition Committee will be affected. In view of above, I so-and-so Registrar of Cooperative Societies in exercise of power conferred under 29(4).
So,
yes,
it is basically a suspension. It cannot be a dismissal because you don't have the exact, it's not established.
Yes, yes.
You want to establish it. How can you terminate him?
My lord, in fact, what is said here, the third paragraph from the bottom, in view of above, I so-and-so Registrar of the Societies in exercise of power under 29(4) of the Act, do hereby bar Mr. T. Hussain, Secretary, from discharging the duty of the Secretary of the Society. Further, in compliance of the Honorable High Court in Session, the resolution taken by the Managing Society as per order of Registrar Assam is hereby approved. So, my lord, with all fairness, this order does not indicate whether, my lord, he has been terminated or, my lord, he has been temporarily suspended, my lord.
So this two paragraphs, the third paragraph from bottom, fourth paragraph from bottom, and the third paragraph from bottom, only reveal that he has been taken up for suspension.
Yes, correct.
So that but if you come to the second last paragraph.
Second last, my lord, yes.
So-and-so resolution taken by the managing committee on so-and-so is hereby approved. So the managing committee under 38(2) had in terms of the directions passed by the registrar, had taken a decision to terminate his services.
Managing committee decision for termination.
That you get it at page 41.
Yes.
Dismiss. So what is the effect, Mr. Talukdar?
Yes. My lord, with all fairness, my lord, the order is contradictory. Once you terminate him, you cannot suspend him. So the first part says that he is debarred.
Debarred from attending, we understand that.
Yes. My lord, this is contradictory. Let a fresh, my lord,
Decision be taken.
yes, taken. Because in the meantime, certain developments have taken place. Audit might have been done, my lord.
Okay. Heard Mr. K.U. Ahmed, Learned Counsel for the petitioner. Also heard Mr. S.K. Talukdar, Learned Senior Counsel, and Standing Counsel, or your Senior Standing Counsel. You can't be standing.
Senior standing counsel.
Senior Standing Counsel.
The standing was missing, my lord.
Senior Counsel, assisted by
K.S. Odial, my lord.
K.S.
So K.S. Odial.
K.S. Odial, Learned Counsel, appearing for the Cooperative Societies Department of Corporation Department. That is the respondent number 1, 2, 3, and 4. Also heard Mr. Anybody government? Any government advocate has any government? Heard so and so, learned government advocate, appearing for the respondent number 5. Also heard Mr. A.K. Sikdar, Learned Counsel, appearing for the respondent number 6, 7, and 8. So the petitioner in the present writ petition has presented a challenge to an order dated 9/11/2018, by which the resolution adopted by the managing committee of Numberpara Sakla SS Limited, by the executive committee, the resolution adopted by the executive committee of Numberpara Sakla SS Limited in its meeting held on 19/3/2018 for dismissing the petitioner from his services, from his services as secretary of the society, with effect from 19/3/2018, was approved. Also, the petitioner was appointed as a secretary of the Numberpara Sakla SS Limited, bracket hereinafter referred to as the society, bracket over, by the managing committee of the society in its meeting held on 27/1/2011. The said resolution adopted by the managing committee was approved by the Register of Cooperative Societies via an order dated 14/6/2011. Accordingly, the petitioner was functioning as the secretary of the said society. Also, allegations being leveled against the petitioner of having committed misconduct during his service as a secretary, the society had executive committee of the society had adopted a resolution in its meeting held on 29/12/2015 to remove the petitioner from the services of the society. So, the petitioner, being aggrieved by the said resolution adopted towards removing him from the services of the society, had assailed the same before this court by way of instituting a writ petition being WPC number 179/2016. This court-wide order dated 21/1/2016, noticing the issues arising in the said writ petition, proceeded to dispose of the same by relegating the petitioner to the forum of the Register of Cooperative Societies. The Register of Cooperative Societies was directed to examine the validity of the resolution under challenge in the said writ petition. Thereafter, the Register of Cooperative Societies by an order dated 17/2/2016 proceeded to examine the said resolution adopted by the Managing Committee of the petitioner, and on such consideration proceeded to set aside the said resolution with a further direction that the petitioner be permitted to continue as the secretary of the society. So thereafter, further allegations having been raised in the matter against the having surfaced against the petitioner in the matter, the Registrar Cooperative Societies wide an order dated 4/12/2017 constituted a committee of two officers of the constituted a committee of two assistant registrar of cooperative societies to inquire into the allegations leveled against the petitioner. The said committee on its on an inquiry committed in the matter submitted its report on 16/12/2017. The Register of Cooperative Societies, on perusal of the report submitted by the said committee, proceeded by order dated 5/3/2018 to hold that the allegations leveled against the petitioner and his conduct as a secretary of the society which was found to have the and the conduct of the and the petitioner was found by his conduct to have superseded the board of directors. Also by referring to a magisterial inquiry report submitted by the jurisdictional executive magistrate dated 21/2/2018, the Register of Cooperative Societies directed the society to take action against the petitioner under the provisions of section 38(2) of the Assam Cooperative Societies Act 2007, read with the bylaws of the society. So accordingly, the executive committee of the said cooperative society in its meeting held on 19/3/2018, considering the materials coming on record against the petitioner with regard to the allegations leveled against him, adopted a resolution to dismiss the petitioner from the post of secretary of the cooperative society with effect from 19/3/2018. The petitioner, being aggrieved by the said decision, now arrived at in his case by the executive committee of the said cooperative society in its meeting held on 19/3/2018, assailed the same before this court wide institution of a writ petition being a WPC number 2532/2018. The petitioner in the said writ petition had also assailed the communication dated 5/3/2018 issued by the Register of Cooperative Societies directing the said cooperative society to take action against the petitioner under section 38(2) of the Act of 2007, read with the bylaws of the society. This court-wide order dated 27/4/2018 on considering the issues arising in the matter and also noticing that an appeal was permissible to be filed before the Register of Cooperative Societies by the petitioner, disposed of the said writ petition by relegating the petitioner to the forum of the Register of Cooperative Societies. The Register of Cooperative Societies was directed to consider the appeal on merit until such consideration was so made and the appeal disposed of, comma, the orders dated, the communication dated 5/3/2018 and the resolution of the executive committee of the said cooperative society, resolution number 1 of adopted by the executive committee of the said cooperative society in its meeting held on 19/3/2018 was kept in abeyance. So thereafter, the Register of Cooperative Societies had considered the matter and wide order dated 9/11/2018 proceeded to grant approval to the resolution adopted by the managing committee of the said cooperative society in its meeting held on 19/3/2018 in terms of the directions passed by the registrar wide his communication dated 5/3/2018. Also, being aggrieved, the petitioner has instituted the present writ petition. Mr. K.U. Ahmed, learned counsel for the petitioner, by drawing the attention of this court to the inquiry report submitted by the inquiry committee constituted by the Register of Cooperative Societies, has submitted that the findings would submitted that the findings of the said committee would go to perusal of the findings recorded by the committee in its said report would go to reveal that there was no concrete material brought on record with regard to the establishment of the allegations leveled against the petitioner. Mr. Ahmed submits that the Register of Cooperative Societies, without appreciating the findings recorded by the said inquiry committee, had proceeded by the order dated 5/3/2018 to direct for initiation of action against the petitioner by the said cooperative society under the provisions of Section 38(2) of the Assam Cooperative Societies Act 2007, read with the bylaws of the society. He submits that in terms of the said direction passed by the registrar, wide the said communication dated 5/3/2018, the executive committee of the cooperative society, without hearing the petitioner, proceeded to adopt a resolution in its meeting held on 19/3/2018 to dismiss the petitioner from the post of secretary of the cooperative society. He submits that the said decision of the cooperative society was so arrived without there being any concrete material before it to establish that the petitioner was in fact that the petitioner was guilty of the allegations leveled against him. Mr. Ahmed submits that in pursuance to the directions passed by this court wide order dated 27/4/2018 in WPC number 2532/2018, the petitioner had approached the Register of Cooperative Societies by way of preferring an appeal. He submits that the Register of Cooperative Societies, wide the order dated 9/11/2018, had approved the order passed by the had approved the resolution adopted by the executive committee of the said cooperative society in its meeting held on 19/3/2018. However, the Register of Cooperative Societies, before according approval to the said resolution adopted by the executive committee of the cooperative society, had drawn a conclusion that in the event the petitioner is allowed to continue in the post of secretary of the society, the process of inquiry and audit conducted by the Register of Cooperative Societies as per decision of the petition committee would be affected. He submits that the Register had drawn further conclusion to the effect that the Register, by invoking the provisions of section 29(4). 29(4) means, what is that?
My lord, in dispute, in respect of dispute between the board and secretary, the decision of the registrar will be final, my lord.
You have that
But
new rules.
It is in fact, my lord.
It cannot be.
No. It is my lord, different. 49(2)L, my lord. In fact, that power is
29(4) is something, there is no
something different, my lord.
29(4).
29(4), my lord. ইয়াতে আছে। Subject to the.
You have 29(4)?
Yes, my lord.
Yes.
What is there?
Different.
Subject to the provisions of this act and the bylaws, the ultimate power of property society shall be based in the general body.
And it's a different, my lord.
It's a different thing.
Yes. Wrongly quoted, but it should be 49(2)L.
49(2)L is that dispute between
The
the
board and the secretary, the registrar's decision will be final.
bracketed SIC bullet with SIC bullet 29(4) bracketed SIC had debarred the petitioner from discharging his duties as secretary of the society. He submits that the order dated 9/11/2018 is contradictory inasmuch as, on the one hand, they said order, it can be seen that in fact the petitioner was actually placed under suspension and debarred till completion of the inquiry as well as audit ordered in the matter by the registrar. While on the other hand, by approving the resolution adopted by the executive committee of the society, cooperative society, in its meeting held on 19/3/2018, the petitioner the dismissal of the petitioner from the post of secretary of the society came to be affirmed. Accordingly, he submits that the said order dated 9/11/2018 would mandate an interference. Mr. S.K. Talukda, learned counsel for the senior counsel appearing for the cooperation department, at the outset has submitted that on a perusal of the order dated 9/11/2018, it is found that the conclusions drawn therein by the Registrar of Cooperative Societies are admittedly contradictory. He submits that the Registrar of Cooperative Societies, after noticing that the statutory audit of the society was hampered due to the activities of the petitioner, had drawn a conclusion that the petitioner is to be barred from discharging the duty of secretary of the society. He submits that the said conclusion would can be only to the effect that the petitioner was required to be kept away from the services of the society till the process of audit is so completed. He, however, submits that in spite of the said conclusion drawn in the said order dated 9/11/2018, the Registrar of Cooperative Societies, by approving the resolution adopted by the executive committee of the cooperative society in its meeting held on 19/3/2018, had in fact approved the dismissal of the petitioner from his services. So accordingly, Mr. Talukda submits that in view of the said inconsistency existing in the order dated 9/11/2018, Talukda submits that the inconsistency apparent on the face of the order dated 9/11/2018 has the effect of vitiating the same, and he submits that this court would be that the same would mandate an interference with a further interference from this court with a further direction to the Registrar Cooperative Societies Assam to dispose of the appeal by carrying out a fresh process in the matter.
In the meantime, my lord, the statutory audits, etc., that has taken place will be considered after hearing all the sides.
After hearing all the concern. Mr. A.K. Sigda, learned counsel for the petitioner, has adopted the submissions made by Mr. S.K. Talukda, learned senior counsel appearing for the state respondents. I've heard the learned counsel for the parties and Also peruse the materials available on record. In view of the submissions of the learned counsel for the parties and the parties having been at idiom that there is an apparent inconsistency in the conclusions recorded by the Register of Cooperative Societies in its order dated 9/11/2018. This court at this stage would not proceed to consider the said order on its merits. First of all, the parties to the proceeding having agreed that the said order dated 9/11/2018, in view of the inconsistencies highlighted by them to be not permissible to be maintained, this court proceeds to interfere with the order dated. This court holds that the order dated 9/11/2018 would mandate an interference. Accordingly, the order dated 9/11/2018 stands set aside. Having interfered with the order dated 9/11/2018, this court directs the Register of Cooperative Societies to consider the appeal submitted by the petitioner against the resolution number 1 dated resolution number 1 adopted by the Executive Committee of Number Para Sakla GP Gaon Panchayats GPSS Limited, in its meeting held on 19/3/2018 afresh. So the Register of Cooperative Societies would now schedule a date for the hearing and issue notices in the matter to the petitioner, the cooperative society, and whom? And the cooperative society and the managing committee of the of the cooperative society, of the said cooperative society. So thereafter, after hearing the petitioner and the managing committee of the said cooperative society, and also perusing the audit reports of the society, if the same has been and the audit report submitted by the authorities after audit of the said society has been completed, proceed to take a decision with regard to the claims made by the petitioner in his appeal petition and dispose of the said appeal petition by way of a speaking order. So, the Register of Cooperative Societies shall initiate and complete the process of consideration of the appeal and issuance of order disposing of the same within a period of 3 months from the date of receipt of a certified copy of this order, along with a representation from the petitioner. Before schedule a date of hearing, the petitioner during the hearing of the said appeal shall permit the parties to the appeal to bring on record any further material coming into existence after the disposal, after the issuance of the order dated 9/11/2018, which has been interfered by this court with the present order. With the above observations and directions, the present petition stands disposed.
Hello, till then, the arrangement with regard to that
post. As the allegations against the petitioner has not been, the petitioner in the present writ petition, having not demonstrated that he is not blameworthy, till passing of the orders, final orders by the appeal, by the Register of Cooperative Societies, after a de novo consideration of the appeal submitted by the petitioner, status quo as on today shall be maintained with regard to the services of the petitioner. Okay, it's not working.
Yes,
There's some IA that may be.
All IAs.
Your
in
lordship
view
will
of the
say in
order.
respect of the post of secretary.
with regard to the services of the status quo as on today with regard to the service of the petitioner as secretary of the cooperative society shall be maintained by the parties. I'll just correct.
Obliged.
Yeah. Yes, Mr. Kunt. How can we help him?
Yes. Not to be. Issue is within a very short compass.
Did you receive revised benefits? You received. Now, you also admit that the resolution that was there, it was only with regard to the pay, not the entire package in the government notification, right? Your pay, your pension is governed by the LIC.
Yes.
Premiums paid to the LIC. There was no premium paid for enhancement of your thing. The premium that they had deposited, they cannot do it also. You can't give a retrospective premium.
That may allow the LIC to escape from the liability, but not my parent.
So for that, you show me that they have adopted the other part also. That you have not been able to demonstrate. That is why you took time the other day to examine that issue. The resolution is specific only to the pay.
Yes, because
and this is an autonomous body that is not automatically applied.
No, autonomous body, even if it is an autonomous body, if they have to pay the gratuity, they have to pay that.
No,
but
they
only
have
in
to pay-
regard to that's whether that 7 to 15 lakhs,
That
whether that liability they will take or not.
No, they are not bound to take it because they have not adopted that thing.
No, I am again on that cutoff date. They have not indicated why they have.
That's what Mr. Last
at
time we
page
stopped
32.
at that only.
Your Lordship will see at page 32.
A query was raised by this court as to whether the adoption of the board of directors so-and-so of the proposal for payment of revised pay to the housefed employees as per so-and-so in its meeting held on 17/6/2017 would also bring within its fold the other benefits which is available to state government employees under the provisions of the ROP rules 2017. They have said in their affidavit.
Adoption is not on peaceful basis, or they have not indicated why.
Yes, they have
done.
said
No,
the board approved the proposal of payment of revised pay to the housefed employees as per ROP 2000. If they have said that we adopt the resolution, ROP.
First, your Lordship will see, but before I take your Lordship, in response to your Lordship query, we had filed an additional reply. That is not on the record.
You can give me a copy.
Extra copy, sir. Copy here. Soft copy here. I can furnish a soft copy. Now,
What have you said there?
No.
Well, it's not far away. We all will go into soft copies.
And they don't waste paper.
It's not very far away. It's near.
Your Lordship will only look into the bold sentences. He today, iPad today. iPad today. iPad today. Tolate ase, no.
The subsequent resolution that you have now assailed here
Yes.
of 2009, it is sometime in 2000.
That is in page 114.
This is only a clarification by the board.
30th
Nothing more
January
than,
2026, Your Lordship.
this is just a clarification. Because, Mr. Kaur, even if we ignore this, the enhancement occasion only with that enhanced premium submitted from 26/3/2018.
Yes.
Before that, there is no. And see, in your case, the gratuity is not given by the corporation. It is given through a scheme introduced by LIC, which they have subscribed. So it will come only through that. There cannot be a second way of paying you gratuity, In that
No,
way,
Your Lordship will first look into the original office memorandum, that is at page 28, clause 7.
No, this is not the office memorandum of the Assam Housing Board.
Yes, which they have adopted.
This they have not adopted. They have only adopted the revised pay in ROP.
Yes.
And thereafter, they say that because of this enhancement, we have given the enhancement to the existing employees on their retirement from 26/3/2018.
Then Your Lordship will look at page 32. There has to be some basis for adoption of the date of from with immediate effect, that is from 26 March 2018.
So whoever retires after 26/3/2018, in view of the enhanced premium paid now, they'll be getting. But how can we ask them to pay or the LIC to pay you that?
No, LIC to Your Lordship will exclude.
And we can't, because that is the manner in which it is being paid. We can't direct them to devise a different manner.
No, this
Mr. Kaur,
this
be
date
it inside the court or outside, the right ear of yours should always give first preference to the better hands.
No, see, Malad, this 15 lakhs enhancement, so means our case is that how can you make a discrimination between these employees who have retired after where was the data or what was the rationale or the intelligible differentiate to include it from?
See,
only
we need
from
not go
26
to that extent. If it was, say, government doing it, we could have said, okay, this is the thing you will have to pay. But here they say that we are a corporation. We are not bound to accept everything the government says. Whatever we accept, that we are to implement.
No, my lord, to adopt this date from 26/3/2018, there must be some discussion, there must be some data.
We can view it in another point of view.
Yes, my lord.
Forget the data. The premium being paid on that day, the enhancement can occasion only thereafter.
So far LIC is concerned.
Because that is the only norm. These amounts say in government, the government pays it. Okay, fine. Why are you making that delay? So we can ask them. Dwarka and all those cases we can bring in. But here, Mr. Kumar, there is a procedure and you have not assailed that procedure.
Into to well, let me deliberate for another one day, but I'll come back to this point. Others will concede, my lord. Give me another one.
No issue.
I will just deliberate
Because people are waiting for such long time.
Yes.
Let us be also very sure. When
Because
we are
the others will concede, my lord, because
No.
I got
Mr. Kaur, my anxiety is that they are senior citizens now.
That's why, my lord,
They have
I
been waiting
don't
for
want
such long
to.
time. Let us also be very sure that they are not entitled.
Because if you are under that scheme, as your lordship has rightly said, then if the scheme is applicable from 2018, you cannot turn back that clock.
Because see, Mr. Here there is one only thing troubling me is payment of a premium.
Yes, that admittedly LIC has
So,
said that you cannot do
Any
it.
person who has retired prior to 26/3/2018, even after 2017, that thing will not be getting that enhanced payment because that corpus is not there. Because the
LIC.
enhancement has not been made by, we can't now direct
To have
payment of
retrospective.
a retrospective premium.
Because that will cause another financial burden on the
LIC.
LIC.
And they are not
that
at
is
all,
that is
they are
again
not at all
public money.
responsible. The matter was heard further today. However, Mr. Ko submits, Mr. Ko, Billy Ko, Learned Senior Counsel submits that the matter be taken up on, let us have it on 18th. You are
Sir?
here?
On
18.
18 months. Oh. Yes.
18/8/2026 for further hearing.
We are
Also,
detailed.
Mr.
We have filed
Billy
it.
Ko, Learned Senior Counsel has submitted that an affidavit in reply on behalf of the petitioners to the additional affidavit filed by the respondent number 3, 4, and 6 was filed on 2/6/2026. However, this said affidavit is not available on records. Registry to tag, trace and tag the said affidavit with the records of this case.
We are blessed.
Who is appearing for the second wife?
Lordship, Senior Counsel M.A. Chaudhary was there, but he informed me that his brief has been taken by the client, Lordship, his client.
R.K. Talukdar 7. M. Dury, V. Achumi, M.K.
5 and 6 they are.
5 and 6. So he is no longer appearing for.
Senior Counsel M.A. Chaudhary is not appearing, Lordship. That instruction I have got. They have.
The others?
Others, I don't idea.
Because they have said many big things in the affidavit. Questioning the, you are divorced.
Lordship, that divorce Lordship is disputing Lordship. So affidavit Lordship, I have not received any copy.
Yes, Lordship, they got copy of the affidavit. I have also
not received any copy, Lordship. So I pray Lordship, let the affidavit may.
It is submitted by the Learned Counsel for the petitioner as well as the
So I will take
Standing
the
Counsel
certificate.
Irrigation.
Lords.
That the affidavit, copy of the affidavit filed by the respondent number 5 and 6 has not been received by them. So the Learned Counsel for the respondent number 5, there is no, none appears for the respondent number 5 and 6 in the present, there is no representation on behalf of the respondents number 5 and 6 today. This matter was last listed on 8/4/2019. In view of the above, the petitioner is directed to take fresh steps for service of notice upon the respondent number 5 and 6 by way of registered post with AD.
A learned friend may also file his affidavit so that it can be clear.
Somebody is getting pension.
Lordship, he is the respondent number 6, Kutubuddin Ahmed, he is getting provisional pension, Lordship, no regular pension.
My
Because
claim is
due to
that
the
my
pendency of the
name
case,
should be
Lordship.
included in the.
The man is alive.
Man is alive, Lordship. Man is alive. He's the party, Lordship.
Number
6.
4 and 5.
No, 5 and 6.
5 and 6. Kutubuddin Barbuja.
Yes.
Oh, he is there.
He's there, Lordship.
He is there.
He is getting.
He's getting provisional
But,
pension.
Who has he declared?
The second
one.
Second.
Kata. It is submitted, then what? You go and file a suit.
Lordship.
If he has declared the second wife as his nominee, what can we do?
Lordship, that record I have not, Lordship. With all respect, Lordship, let him.
There is heard Mr. K. A. Mujumdar, Learned Counsel for the petition. Also heard Mr. N. Upadhyay, Learned Standing Counsel, Irrigation Department.
They have also not filed.
So, There is no representation on behalf of the respondent number 5, 6, 5 and 6. 5, 6 and 7. So, Mr. It is submitted that the respondent number 5 is the husband of the petitioner number 1. Mr. N. Upadhyay, Learned Standing Council, Irrigation Department submits that the the respondent number 5 had nominated the respondent number 6 as his nominee in his service records. Accordingly, in the PPO, it is the name of the respondent number 6, which is reflected as the wife of respondent. Service records so and so, service records are quoted. Yeah, Mr. Upadhyay to file an affidavit in the matter, bringing on record the declaration of family particulars by the respondent number 5 prior to his by the respondent number 5, either prior to his superannuation and or thereafter in connection with processing of his pension and pensionary benefits. So, registered to list this said affidavit to be filed on or before 10/8/2026. Registered to list this matter again on 19/8/2026.
I have the document, Lordship. I can give.
You file just
Lordship,
2-page
then,
affidavit.
Madam,
Then if that is
Lordship, I am not disputing Lordship. If anything, I am not getting in record Lordship, nothing Lordship. For
Happy Lordship, last listed on 19, Lordship. Now it has been listed without his Lordship.
much obliged Lordship.
Yes.
Other sides has not filed their affidavit, madam.
Perhaps Lordship may not like to take up this matter. This matter pertains to the Sahayak regularization. Lordship has appeared.
Okay, registered to list this matter before any other bench without me. Okay. That division bench and all those.
Yes, my lord.
Okay.
Lord, in this case, Lordship appeared.
I appeared.
Yeah.
Oh. For the
picture.
Where? Any order?
In the WBC 1068/2011.
One?
What? Alias proceeding.
Huh?
WBC 1068 of 2011.
It was argued by Mr. Dasgupta. Earlier I was appearing.
Yeah.
Same order. So matter insurance. Let me the version. Yes. What happened?
Lordship, my senior is on his way. Please come.
Have you got any provisional pension?
No, my lord.
Item 16. Please, Your Lordship. Lordship, we have already communicated with the department on in the test pool, Deputy Director, Dairy Development Test Pool. They have given some records. In these records, the petitioner name was not there. We need some time to.
On the prayer of Ms. M. Konkuti, further the matter stands adjourned. On the prayer of Ms. M. Konkuti, further 2 weeks' time is granted for completion of her instructions. No further 3 weeks' time period. No further adjournment shall be granted for completion of instruction by the Learned Council for the respondents. Registry to list this matter again on 28/2026.
Obliged.
Wait, please, Your Lordship. Your Lordship, this is a case where I'm paying for compensation.
Before Mr. Dury, you start. Why an affidavit in reply was not filed by you?
I was seeking some instructions, Your Lordship, but the petitioner, there was some communication gap, Your Lordship. She didn't.
So there is no scope of filing a rejoinder.
I am trying. Yesterday also I tried, Your Lordship. I'm not getting any response from her.
Because if you don't dispute these facts, how can we come in your favor? Because a compassionate appointment can be made within the confines of that scheme. They say that you are not class 10, so you don't get it.
Yes, sir.
That's the end of the matter. Second, CPF, they say it was introduced in 2017, rightly so. So it cannot be given a retrospective effect because your husband died in 2016. Take me 2 minutes to dispose of the matter. But
Without an affidavit, I will try 1 week.
On the prayer of Mr. T.S. Deori, Learned Counsel for the petitioner, a last chance is granted for filing a rejoinder in the matter by the petitioner to the affidavit filed by the respondents. Also, the said affidavit be filed on or before 14/8/2026. Registry to list this matter again on 24/8/2026.
Very grateful, Your Lordship.
Please, Your Lordship.
In this case, petitioner before Your Lordship was pharmacist.
Anything further to be heard here? Nothing.
No, I submitted one affidavit, basically with judgment, my lord. And I have
But the parties for at some length, hearing concluded, registry to list this matter again on 20 तारीख केटा association a delivery of order 20 August. (28) 2026 that 9 again na fix for delivery of orders.
Senior is on legs, Your Lordship. Can I take up the matter after some time?
Yes, where is Mr. Bishop?
He is on the way, Lordship.
After some.
Really possible. Ready to.
Lordship, my learned friend, Mr. M. Sharma is on his legs in another court. This is a matter about the competition of gratuity.
After some.
Highly obliged, Your Lordship.
23.
Maybe Lordship. This case, my Lordship, kindly see order, my Lord, 8/12/2025. There is no certificate was issued, my Lord, regarding the, no one is issued, my Lord, 11/5/2023 and.
10/5/22 is it appears to be a
pass.
Huh?
it appears to be a fixed.
Fake certificate.
Yes, my Lord. Our certificate is genuine, my
His
Lord.
account was closed on 11/5/23.
Yes, at that time he was default.
The manager has also clarified in writing that he never issued any such certificate.
Yes. Who is appearing for the private respondent?
It's only number 5.
Huh? You are appearing. Your name?
B. Datta.
Where is Mr. U. Datta?
Datta is yesterday, Lordship, he sleep and fractured his legs, Lordship.
Ask him to come online. A very serious position now. If that certificate is fake, your appointment goes. Because we have, that's why 2 certificates? 10/5/2022 is the certificate page 104. That is fake. And your certificate is at?
57, my lord, page 57 deed petition, my lord. My certificate.
So this is correct. Mr. Ganguly?
The account was actually closed on 11/5/23. He has shown by the other certificate that it was closed on 10/5/20.
107.
Certificate is 10/5.
104.
105 certificate, second certificate lordship. 11/5/2023.
So if your loan account is closed on 11/5/2023, you had a liability. And how can you be appointed? So we'll interfere with your appointment. Okay? Any issue? Say something.
No,
You want time, you tell me you want time. If you want to argue, you argue. You want to argue or you want Mr. U. Doctor to argue?
Doctor.
Why are you so shy in saying? You be bold. Bolt out. Say that, sir, give me time. That's all. We'll give you time. And if medical emergency is there, we'll give you. But you ask me. Now you ask me, what do you want to do? Tell me, what do you want to do? If you want to argue, you are most welcome. There is a statement on record. When was the last date, Mr. When was the last date for the submission of application?
My lord, last date was 8/8/2022.
8/8/22,
my lord.
Advertisement is?
Advertisement was 7/7/2022. And selection was done, my lord, 6/4/2023.
There is a certificate here, Finacle Rashidul Haq is the respondent.
Yes, my lord.
It says that on 27/8/2021, what is the account number?
Account number, my lord.
Page number 105. Second line, lordship. 726925 00169.
726925
60.
But Mr. Ganguly, there is a bank statement here.
That affidavit has got, sir.
No. This was given, handed over to me by on 17/12/25. By Mr. S. Dotto, Learned Senior Counsel. This is the bank account, a bank statement, wherein on 27/8/2021, the balance is shown to be zero. I don't understand what this is. Forgot.
On that reason, my lord, the Honorable Court directed to implement the party, the bank authority, my lord. So you implemented the bank authority, my lord.
I would need a copy of this statement.
Just, you have that statement?
Lordship.
On that ground.
Show me.
Bank manager clearly, my lord. I also the report also, my lord. So report directed to implement the bank manager. Initially was not party, my lord.
This is on record, lordship.
This is the statement. Mr. Ganguly, this is the statement. Can you just have your instructions on that?
Because the statement that I have also is showing only balance transfer. I have to take description.
Because this was produced by Mr. Dotto from the bank. You please get up. You give him a copy of that bank statement also. Because that is produced by the bank only. It is signed by the Assam Gramin because Habib Bora Nagori Bank. Bank, huh? Mr. Ganguly, learned counsel appearing for the Assam Gramin Vikas Bank submits that the certificate dated 15/7/2023 produced by the petitioner in the annexed by the petitioner to the writ petition as Annexure 7 was issued by the bank authorities, and the loan account of the petitioner was closed on 11/5/2023. With regard to the certificate relied upon by the petitioner in his affidavit dated certificate dated 10/5/2022 relied upon by the respondent number 5 in his affidavit. Mr. Ganguly submits that the said affidavit was not issued by the bank authorities, right? Not issued by the bank authorities. Also, Mr. Ganguly submits that with regard to the earlier bank statement produced by the bank, wherein it is revealed that as on 27/8/2021, as on 1/12, okay, you get your instructions. Mr. Ganguly further submits that he would receive further instructions and also further instructions as to whether the loan was completely liquidated by the petitioner, by the respondent number 5 on or before 10/5/2022.
Better than my oral submission, let me get it out. I'll file it.
No, affidavit or something.
This is a loan, balance transfer is, because it continues. It is only shown on 11/5/2023. Since it's a loan account, it's shown as a balance transfer.
Okay, just clarify. We don't know. We are not only that saving bank. Raised it to, when can you have the affidavit?
Yeah.
Huh? We file it before the Independence Day. Let the affidavit be filed on or before 14/8/2026. Raised it to list this matter again on 28/2026 for further hearing. Wait, Joseph. Yes, Mr. Goswami, anything done?
Received some instructions.
Mr. Sharma, how is your leg now? Fine. You had a fall.
I'm not documented. Still fine.
Yes. You take your seat. Don't exert yourself. No, Mr. Goswami, you are reiterating the same thing. We asked you why that promotional scheme is not permissible to be made. That's all. They are entitled to a MSAP that is written on the stone. That cannot be now done away with. They can be encadred with some other post. They can be upgraded to some other post. Something.
It is paragraph 6 of the judgment, Lord.
Oh.
That's a- yes.
Your secretary is acting smart. We had for formulation of an appropriate scheme for providing promotional relief to the petitioners was not complied with, and the matter was disposed of by only holding that MSCP scheme formulated in the matter would redress the grievance of the petition. MSCP scheme was there when the order was passed by this court. This court knew about it. We don't accept such things, Mr. Have you forwarded a copy of this order to your secretary?
That order, Lordship. Yes, so far in my yes, in my letter we submitted. I submitted that the order passed by the passed on 7/11/2022 passed by the Honorable Gauhati High Court in WPC 4612/2019 and the speaking order dated 24/06/2024 passed by the Secretary to the Government of Assam. Food and Sales Authority. That order was sent, Lordship.
That my order, 15/7.
15/7, Lordship.
Can I have the communication you sent?
Yes, Lordship.
This is not what we wanted. We wanted, why did you speak to the MSCP? That is there, that anybody is getting. But their grievances, we don't have promotionals, promotional avenues. So their data entry operators, they are getting scale of junior assistant. They can be attached to that post, adjusted against that, or amalgamated with that. Something can be done.
That line, Lordship.
Because when the rules were framed, naturally there were no computers,
Lordship.
just typewriters.
Lordship.
So data entry operators could not have been visualized by the framers of the rules.
Lordship.
Why is your secretary acting smart?
On that count, Lordship, I have to take instructions.
I think we should interact directly now.
Well, Lordship, I will ask to.
We asked you. On the Mr. J.K. Goswami, learned additional senior government advocate, submits that he be granted further time till when?
Lordship, August 1st, Lordship.
Till 5/8/2026 to receive receive instructions with regard to to complete his instructions with regard to the query raised by this court on 15/7/2026. Prayer accepted, raised it to list this matter again on 5/8/2026. I'm not referring to this. If I refer to this, then again I'll have to take some stern action. I have faith in you that you will do it the needful.
Yes, Lordship.
Kindly do that.
Lordship, what happened, Lordship? Sometime what happened during short period when we try to obtain the instruction, Lordship. So same day of the order we send our letter. But difficulties is that, Lordship.
Sometimes the order is not uploaded.
Order is not uploaded, Lordship.
So when the order is uploaded, you should download it and send it.
No. I got now this time, Lordship. I got sufficient time because the order will upload.
On that day itself, it was uploaded.
Lordship.
You have download both the orders and then
Lordship,
send.
yes,
You get this order today.
I will do accordingly. That.
Continue করা।
Item 25.
Lordship, in this matter, Lordship, Miss L. Devi is appearing for the Tejpur University, Lordship. I am appearing on behalf of Miss L. Devi. Lordship, may grant 3 weeks time, Lordship. We have sent the affidavit for vetting, Your Lordship.
Mr. D.J. Das, learned counsel, appearing on behalf of Mr. L. Devi for the respondents, learned counsel for the respondents number 1 to 5, submits that the affidavit has already been prepared and is in the process of vetting. He submits that he be granted further 3 weeks time to file the said affidavit.
Well, I'm appearing for the UGC.
Mr. Dr. H. Omua is present on behalf of the UGC authorities.
Much obliged, Lordship.
Item 42 was to be.
We'll take it up. We are just coming to that. Few more matters, we'll just finish it and come to 42. You have filed the affidavit?
Well, the difficulty is that I could not get it signed by there, but they have signed it digitally. And I have signed it for filing also. One copy I have.
Have you given a copy to the?
Just taking the consent of this honorable court.
Orders have been passed?
Yes, Your Lordship.
But Mr. Ayat Soikia, learned counsel for the petition, also heard Mr. Miss H. Terangpi, learned standing counsel, secondary education department. The petitioner in the present petition has raised a grievance with regard to the has presented a challenge to an order dated 7/2/2026 by which the director, issued by the Director of Secondary Education Assam. Where is that order?
Page 26.
Allowing the jurisdictional inspector of schools to hold the charge of the post of headmaster of Milan High School, Bargacha, Nolbari. Also, the petitioner has projected in the next petitioner has projected in the petition that he is the senior most teacher in the school and having all requisite criteria, possessing all requisite criteria for promotion to the rank to the post of headmaster in a provincialized secondary school in the state. Also, he submits. It is also projected that a vacancy having arisen in the school on the incumbent in the said post retiring therefrom on 31/1/2026, it is the petitioner who was to be allowed to hold the charge of the post of headmaster of the school in view of his seniority therein. So it was projected before this court. Next, the learned counsel for the response test, the learned standing counsel, Secondary Education Department had projected before this court as there was an inquiry pending against the petitioner with regard to certain allegations raised against him, the petitioner was not permitted to hold the charge of the post of headmaster of the said school, and the jurisdictional inspector of schools was permitted to hold the charge. Also, Ms. H. Tanangpi, learned standing counsel, Secondary Education Department, has today placed on record an order dated 22/7/2026 issued by the Director of Secondary Education Assam. Also, a perusal of the said order would go to reveal that on conclusion of the inquiry conducted against the petitioner, the allegations leveled against him were found to be false. So accordingly, the Director of Secondary Education, while the said order dated 22/7/2026, has permitted the petitioner to hold the charge of the post of headmaster, Milan High School, Borgosa, Nalbari, along with financial power to draw and disburse the salary of the staff, in addition to his normal duties as graduate teachers, invoking the provisions of FR 49 bracketed C of the FR and SR. So, in view of the issuance of the order dated 22/7/2026, permitting the petitioner to hold the charge of the post of headmaster of the school in question, the grievance raised by the petitioner in the present petition stands redressed. So, there being no further live issue for consideration in the matter, the present petition stands closed in terms of the said, in terms of the permission, in terms of the direction, in terms of the order dated 22/7/2026 issued by the Director of Secondary Education, Assam, allowing the petitioner to hold the charge of the post of headmaster of the school in question. A copy of the order dated so and so is kept on record and marked as X for the purpose of identification. Close click one I need. Close click.
Lordship, in this case, Lordship, we have to file our affidavit, Lordship, reply. Yesterday we have.
Mr. DJ Das, learned counsel for the petitioner, prays that he be granted 3 weeks time to file a reply on behalf
Lordship,
of the petitioner.
2 weeks, Lordship.
2 weeks time to file a reply on behalf of the petitioner to the affidavit filed by the respondents.
Can I pray for a
Pray
date, Lordship?
accepted registry to list this matter
Lordship.
again after two.
I'll approach the registry, Lordship.
Next.
May I please, Your Lordship? Lordship, conducting counsel could not appear today due to his personal difficulties. So
What is his name? What is his name?
MH Ahmed.
MH?
Ahmed.
A prayer is made on behalf of Mr. MH Ahmed for an adjournment in the matter on account of personal inconvenience. Prayer is not objected to by Mr. H. Alia, learned counsel appearing for the respondent. Raised in view accordingly raised it to list this matter again after 2 weeks on a date to be fixed by.
May it please your lordship.
Provisional pension given.
Well, this service is not pensionable. Well, I have obtained an instruction.
Okay.
I like
Miss P. Chakraborty on instruction submit that the petitioners that the service that the petitioner had not rendered a service. Not rendered a service in a pensionable establishment, and accordingly pending finalizing and accordingly there would arise no occasion for authorizing to the petitioner a provisional pension pending finalization of his pension and pension benefits. The said position is disputed by Mr. R. Sharma. Ms. Chakraborty to file an affidavit incorporating the said fact and file the same within a period of 2 weeks from today. The instructions furnished by Ms. P. Chakraborty is kept on record and marked as X for the purpose of identification. Your
Lordship, S. Sharma on behalf of Mr. B. Sharma for Accountant General.
Ms. S. Sharma is present on for the respondent number 6.
In 30, 31 and 32, my lord.
Huh?
Item 30, 31 and 32.
30,
These are, my
31
lord,
and
covered
32.
by Supendra Bachcharji.
Huh?
Supendra Bachcharji.
That issue.
Case, my lord.
But the matter is pending before the division
Yes,
bench.
that has been heard, my lord, judgment has been reserved.
Yes.
Reserved. In terms of
Other cases, lordship was fixed on 29th.
we'll have this on 29th. only. Registry to list this matter 30, 31, 32. As agreed to by the Lana Council for the parties, registry to list this matter again on 29/7/2026.
Nice.
Dear.
29-7, my lord.
29-7.
My lord. Obliged, my lord.
33 also, same. 31, 32, 33.
30, 31, and 32.
32.
33 similar issue, Lordship.
Similar. Regularization.
32, my friend's case is regarding regularization. But my case is for minimum case.
Oh, okay. 33 to Belek query. It is submitted 33 submitted that the submitted that the issue involved in the present writ petition is not similar to the one involved in WPC number 337/2026, and accordingly it is prayed that the present writ petition be detached from WPC number 337/2026 and listed separately. Prayer accepted. Registry to detach the present writ petition from WPC number 3337/2026 and list the same again on 7/8/2026.
My case is 3256.
3256, will be detached from 3337/2026.
And will be listed on
7/8. Yeah, I get it. Yes.
Lordship, meta may be taken after some time. So there is
42.
Lordship, we have filed an affidavit with some difficulties, but in any case, that decision-making process has been annexed along with some other documents which are not very relevant. And in the affidavit pleadings part also, we have inserted the relevant portion of the note sheet.
You have got a copy, Mr.
Right now, just now I have got a copy.
Now you have got the minutes yesterday. The note sheets. Have you gone through that?
Lord, I have gone through it, my lord. Lord, I'll make my submission after the respondents, my lord, completes their submission, my lord. Because
okay. Accept.
so far as the note sheet is concerned.
So our case is plain and simple.
So far as this is concerned, my lord, we have said so many things, my lord, in this bulky.
Mr. Soikia has made his submissions yesterday.
Yes.
Basically, Mr. Soikia's submission is in 3 compartments or 3 projections. One, that the PhD degree is not the one that the PhD degree was obtained by you without taking prior permission from the authorities.
Correct.
We find from the OM prima facie that going by the literal meaning, simple meaning, that this is a permission which you take when you actually apply, actually join. But coupled with that, there was a departmental proceeding instituted against you on the same very issue that you did not take permission. You did not challenge that finding. So a misconduct was apparent. You did not challenge it. We reject Mr. Saikia's first contention to that extent. That the OM says, but again, Mr. Saikia has reaffirmed that allegation that they have leveled by holding an inquiry properly. Whether that inquiry is proper or not, this court in the proceeding cannot go into. So that is one counter. Second argument of Mr. Soikia is...
He has accepted and he has accepted the punishment also.
That's what I said. So that...
Not only challenge, but the punishment also he has accepted.
Mr. Saikia, that gives you a coverage of what you have projected. Also, the OM may have some other interpretation. Second argument of Mr. Saikia is that this is not a degree which is required for the job you do. I have my reservations. Because if I lay down that it may become a law and it may hamper many others. So I don't accept that. Now comes the vital issue that sparing you would undermine the works of the university. And Mr. Das, for arriving at this conclusion, it is Mr. Soikia who is the, Soikia means the institute,
authorities,
who is the authority who has to take that call, even in terms of leave rules 50.
Fine.
So once they have taken that call with regard to leave rule 50, and they have said that given the, and Mr. Saikia's argument is hedged with the works which have been set out in your appointment order, wherein it says that this being a single cadre post, this is not required. Now I come to the notes.
Yes.
In the notes, there are many things which have been said.
Yes.
But Mr. Saikia yesterday had from that order pointed out one thing. I could not appreciate it at that point of time. He said, for the time being.
For the time being.
Mr. Saikia had made that, but I did not appreciate that yesterday. But when I went through this note, if you come to note number 21, that is given by the competent authority, that is the director. It is in the 1, 2, 3, 4, fourth page. See, he has not foreclosed it. He has not foreclosed it. He said, given the issue, 6 months, you have to be there. We cannot spare you now. As per the analysis in, it is decided to postpone the application for future, may not be allowed for this time. So this is something which appeals to this court. And in view of your service, your deterioration, you not having taken steps in that APRs which have come down to poor, it's a different issue whether you are always at liberty to follow Devdutt and all and do whatever you want. But this issue, when I read it into the provisions of section 50, Mr. Saikia, this is the area you want to.
I have already made my point here, and Lordship has
if you come
only
to
taken note of
page
my
50,
submission.
Mr. Das.
Yes, madam.
If you come to 50, section
Yes.
50, rule 50,
Rule 50.
subject to the conditions specified in this chapter,
Yes.
study leave may be granted to a government servant with due regard to the exigencies of public service to enable him to undergo so and so. So that aspect, because prima facie, there is material.
Not,
Mr. Saikia, you can have this.
after your lordship's, my lord, words, my lord, what I can gather is that, my lord, the most important point now boiled down is the administrative exigency. Keeping aside everything, my lord, the other aspect, my lord. Because the other
aspects I'm with you.
Other aspects which has been, my lord, urged by the respondents, my lord, they are not, my lord, not in conformity with the rules, my lord. Rules do not
Rules,
prescribe.
this is the issue.
Yes. The main issue is with
And
regard
one more
to
thing I just point out to you,
which invariably would affect
with such frequency so as to remove him. 6 also somewhat supports the opening paragraph of 50. 6 subclause 6 subrules. Not in that context, not in that context. The cadre difficulty is owing to his difficulty.
So
the last part.
Main issue is
This. What do you have to say?
It would affect, my answer to this lies in my prayer in the writ petition vis-a-vis annexure R8 of their affidavit.
Okay, we'll go.
Lordship will kindly have a look at my prayer first. Page 27.
Issue a writ of certiorari setting aside causing the impugn email, that email, my lord.
That is what there.
Then number B, issue a writ of mandamus directing the respondent number 2-3 to issue NOC, grant permission to the petitioner to allow him to join a PhD civil engineering program initiated by so and so. So my prayer before this honorable court is very specific to permit me to do the PhD and grant me NOC. Nothing beyond that. Now, if your lordships kindly turn to their annexure R8,
Page 113.
113. In response to your RTI query, please find the reply pertaining to NID Assam Jorhat as below. Requested to provide the details pertaining to higher studies pursued by the faculty and staff, members of NID Assam while working at NID Assam since June 2019 at present December 25. Now they have given a list of 15 persons. Out of these 15 persons, my instruction serial number 7, my lord will see, he has been granted NOC. Sunil Kumar Bonia, staff, head security service. He is doing PhD, it's a single cadre post, my lord. He is doing PhD in management. Then, my lord, serial number 8, who initiated the note sheet to reject my case. She is doing PhD in Kaziranga University. She is holding the post of registrar stroke CEO. Single cadre post. PhD in management. Then serial number 9, who squarely similar to me, my lord. Mr. Sukriti Saha, faculty, senior faculty working, PG diploma in communication. He is doing PhD in Tezpur University, single cadre post. And he is a senior faculty and academic chairperson.
So in that department of diploma in communication design, there is no other faculty.
No other faculty. These are all single cadre posts, my lord. These are all single cadre posts. Because we don't have, my lord, our promotion policy is not there. I have taken instructions, my lord. There is no promotion policy. My post is also single cadre. This post is also single. If these persons can be given NOC, my lord, holding a single cadre post, CEO, my lord, CEO.
This is in your reply you have given it. No, in
Lord,
their affidavit.
Their affidavit, my lord, they have given this, my lord.
So where is the pleading to that effect in your reply?
I can explain, my lord. In my reply, my lord, I did not give much credence on this. The reason is that I did not know that my case was
Mr. Das.
I can take.
And Mr. Das, no, it's not that. This is a material available.
It's an admitted factual position.
But the projection you are trying to make,
yes,
that may not be known to them, the councils.
It was also not known to me that
so now
my
that
case was rejected
this
single
plea that you have now taken, say this court is giving importance to this matter because tomorrow is the last date.
Last date.
So I'll have to finish up this matter today.
Yes.
If you agree that, okay, the issue be decided, it's an academic issue, I have no issue, I can fix it on Tuesday. But thing is, now if you have developed this argument,
yes,
without giving an opportunity to the respondents to respond to that.
Look, things are coming like this in a ziffy, my lord.
No, this was something
what I'm submitting it.
Mr. Das,
yes.
I understand your issue.
Yes.
I understand. But this is something which was there on record.
Yes.
If this, see, there
they
are
have
many,
said that they have given NOC to this person.
So that is,
it's an admitted factual.
They have only said that. But the further projection now that you are trying to develop, that these are single cadre posts.
Yes.
These people were given, I am discriminated against.
Yes.
Now you are bringing in an angle of discrimination.
Correct.
So it's a different perspective to this basic document. It's an interpretation you are making on a basic document.
Yes.
That they don't have.
Yes.
So we can't give an answer on that today, basing on your this submission. It may not be proper.
Milord, I can file an immediate affidavit, very short affidavit, only projecting that aspect of the matter, because I have got documents also. Milord, I haven't placed it, Milord, because it may not be proper. So I
But
can
again,
find
Mr. Das, study leave is in relation to
study
a
leave.
person.
Milord, I'm making one submission. Milord, study leave is a consequential thing. Tejpur University, I'm Tejpur University, for making admission, they don't require study leave, Milord. They require only NOC.
Mr. Das, that is the beauty of that provision. Once the NOC is given, with the knowledge that you have to undergo 6 months.
How these persons are doing 6 months?
Because they may have been given study leave. We don't know.
That's right.
We don't know whether they have been given study leave or not.
So without going
Now
by the submission of the
Mr. Das, this is a very serious
I'm sorry.
issue. Now, giving you an NOC, consequential action is that the study leave must be given because they have consented to your pursuing that course. So the conditions of that course will apply, or they can deny you a study leave.
Yes, they can deny me study leave.
So are you saying that you proceed to undergo that 6 months course, you will not receive any salaries?
Yes, in that even if they
Are you agreeing to that?
No,
that you
because
if you are,
I'll
ask Mr. Saikia to give you an NOC.
Yes.
With the condition that you will not claim. They will not take any unauthorized thing for that, but you will not claim any salaries for that period.
Look, I have the option of asking for UL also. In the UL, there is a provision.
No,
20
tell me either or. Whether you want a salary or you want UL 6 months.
Lordship will give me 2 minutes time, Milord.
But I don't agree to that, Lordship.
You need not.
I don't
No,
agree.
it's just I'm trying to take out a point. You need not.
Lordship,
So, Mr. Saikia, why he has objected to is because his main plank of argument is that they can't spare you.
That falls flat because of the reason of violation of Article 14 discrimination.
That discrimination is not a ground of challenge in the present writ petition.
That's true, Milord. Discrimination ground I have taken in the writ petition, but not specific with regard to this, Milord. Because this fact, Milord, I can file a short affidavit by Monday, Milord. Or Monday I can file a short affidavit.
But by the time your time is over,
Milord, that is what. Milord,
your time is
my
over.
friend makes the submission for me.
No, forget him. You are you discuss. You address the school.
My prayer is that, Milord, classes are starting from 29. Tomorrow is the last day. If my lord permits me to take admission, in Tejpur University, at best what will happen, my lord? My writ petition if dismissed, my money will go, but my candidature will be protected. At least that much, that for this tomorrow, if my lord permits me to take admission, lordship will take up this matter on Tuesday. I'll file the affidavit on Monday. I'll urge these grounds, my lord.
So, if you file the affidavit on Monday,
yes,
I'll have to give them at least a week's time because they are an organization. They'll have to.
29, not overnight. This bulky affidavit has come, my lord.
This is nothing. This is just bringing on record that thing. But this is a issue. They'll have to now take it to the root.
Nothing, my lord. They have already said that they have given NOC to these persons. They have already said that they have given NOC to this person by page 113. It's not in dispute at all. Milord, my instruction from the client is that UL will not be an issue, Milord. He can.
That they will not because if they agree to that, if we direct and they agree to that, their very basis will go. That Mr. Saikia.
Oh, fine, Milord.
Will not agree.
The respondents may agree, may not agree, Milord. I am not on that, Milord. My humble submission is going by the law.
But Mr. Das,
yes,
once they have emphatically stated and their whole noting is We are only, see, the decision is not of any concern
I
to
can
me.
also substantiate before your lordships with records that the decision that to line of the chief administrative officer are perverse. I can also substantiate
No,
that.
I'm only with that notification
So,
with the
My
rules
instruction
there.
is that for next 6 months, my lord, I don't have any work in the institute. That is my instruction. My work has been changed. Whatever was there in the appointment letter.
You have not brought all these things to notice.
No, things have come yesterday only by virtue of a note sheet that for this reason you are, that's not accepted.
No. The affidavit had clearly stated that they can't spare you because of
That's
the.
a different thing. Or
No.
neither the
There you have not responded by saying that, see, my whole scope of work is now different.
nowhere in the affidavit.
Okay,
there
we
is
permit you.
single line, my lord,
Miss
saying
Devi, Miss
Lordship,
Devi.
one thing I would like to say, he is citing some instances, 15 persons, and one name belongs to him also.
And that is
the
No, whatever.
earlier
So he was
Miss Devi,
beneficiated the same
Miss
process.
Devi, who is appearing for the Tezpur University? You are appearing, Tezpur University? Huh? Can the admission, if we allow him, be given to him on 28th? Can you take that instruction? The classes begin on 29th.
Yes.
So the admission also on 29th, and he joins if we allow. If we don't allow, that's the end of the matter.
Yes.
Can you take that instruction? Come on.
Lordship,
Yes.
one thing that this will again arise another enforceable right. If he takes admission, next stage will be.
I'll not permit him to take admission. That is why I asked him whether 29th the classes are beginning. On 29th the admission is permissible. If I dismiss the writ petition, that is the end of the matter. Because if I
suppose Lordship allows that.
Today I allow him.
Today Lordship
Allow him.
allows him to take admission. Fine.
Tomorrow I dismiss it.
No. It will happen. The next course of action will be on Monday or Tuesday. We will file the affidavit. We will take at least 10 days time because we have to identify and take the background check of each of these persons, how the exercise was done to grant them permission. It will be a long run process. Then 15 days, 20 days will go. Then again, fresh hearing will take place.
Then they
will say, Lordship will ultimately have the sympathy
to give.
Please give him.
That is what I want
That I do not want, Lordship.
No, I want to prevent that myself.
No. If the admission is taken, Lordship, then suppose tomorrow Lordship dismisses it. Once it will go waste.
Okay.
There is already an interim order by
that interim order is actually ruining the career of one another person who ought to have got it.
My lord, there is already an interim order protecting.
If there is a right, then I'll argue all the legal points now.
My humble
Up to what level the Honorable Court would also like to go, that is also prescribed by the Supreme Court.
Mr. Soikia, let the counsel go from this court.
The Lord
satisfied that he had done everything yet. That much so.
I leave it to this
I'm
Honorable
stuck in one point, and Mr. Das is trying to
and
take
we are
me out.
also, my person came from Tiok. Halfway he had to go back vacant because of the flood. Then all these things we have taken, we have burned the midnight oil also to file this affidavit.
Mr. Das.
Yes, my lord.
What is the change in the scope of your work?
My lord,
Where is that order? Any order to that effect?
yes. What has been done, my lord? They have said, I have to deal only the works beyond 15 lakhs. Below 15 lakhs, work has been taken to an assistant engineer, has been given to an assistant engineer. So my scope of work becomes very limited. And
No,
projects
when was
below
this order passed?
2023.
So this whole thing you never urged?
Not able to appreciate, my lord, this was never.
No, Mr. Das, one
No,
thing.
this was never an issue.
No, it was an issue because in the affidavit, there is a categorical statement to that effect.
Saying that there are works pending because of which I cannot be spared. Nowhere, my lord, I have read several times the affidavit.
You come to para 14.
Yes, that the petitioner was appointed as a post of senior engineer land building so-and-so, joint service so-and-so. The said post is an operational, technical and isolated post with direct responsibility for, this says about my work duties.
Now you
This
come
was-
to the noting. Note number 20, last paragraph.
Note 20, yes.
The last but one paragraph. Further.
Further, as for, yes, UGC guidelines, the presence in the station of the university during coursework at least one semester is mandatory, and as Tezpur University is far off from Surat, station leave of nearly 6 months would require to complete the coursework, which invariably affects so-and-so. It can be inferred that his own efficiency towards so-and-so.
And also from his previous, that's a additional,
No, there is not-
it can be inferred.
If this note sheet is neither reflected in the impugn order nor in the affidavit, 32 paragraphs affidavit.
No, but.
Not a single whisper of
Mr.
this.
In the affidavit, they can, even if they can't say something which is beyond that. But now
First of all, they cannot improve their case.
they can't take, they are not
They cannot
improving.
improve their case.
They are not improving their case because this is the basis for which the decision was
Which
made.
given you.
Fine, but this court can go into the contemporaneous records. This court has seen the.
I want your lordships to go,
This
I want
court-
your lordships to go.
this-
That's why
this-
they've asked for, I'll file an affidavit.
This is the,
If this is the contemplation
Hmm.
that a single cadre post, your sparing will create chaos in the office. If that be so, then what about those persons, chief executive officer, she is doing PhD, no problem, NOC has been granted, but that same chief executive officer, Milord, is rejecting my case. Is it conceivable, Milord? I ask myself, Milord. Is it conceivable?
what is her name?
NOC, Dulumoni Kolita.
She is the registrar.
Yes, registrar and the chief executive officer,
Chief Administrative.
chief administrative officer, sorry, Milord. CAO. That is my plan. So that's why I'm saying, Milord, only to avoid any prejudice to the petitioner, Lordship may permit me to take the admission. Let the matter come up in the next week, Tuesday, Milord.
No, once you raise that plea, I'll have to give them sufficient time.
That's why I have said.
No,
Milord,
Mr. Das, once you give that plea that these people were given, they'll have to dig out all those facts behind giving them NOC from 19, 18, 17,
At the
16.
same time, my lord will also see that after issuance of notice, how many occasions they have got time to file, to bring on this note, to bring on record the reasons given in this note before this honorable court. Never brought.
That may be an inefficiency. We will not go into that.
No.
But Mr. Das, I'm sorry.
I'm not saying that your lordship will take a decision on that. What I'm saying is that, Milord, what my submission is that, Milord, time is all right. But if they tomorrow say that we need 1 month time to respond, Milord, I am in a fix. I cannot.
Okay,
Milord,
there is already an interim order that
Yes.
your candidature shall not be cancelled.
if I don't take admission in this semester, autumn session,
This order is of the court.
it's true, Milord.
Oh.
If I don't take admission, Milord,
We are not, until and unless we are satisfied that you have made out a case for interference with the interim order, we are not passing an interim direction. Further interim direction. Because this court, of the 3 grounds urged by Mr. Saikia, 2 grounds we have rejected.
the
third
main ground which has been
Yes.
urged yesterday only by what
Late fine. Okay.
that much only.
We'll hear, let him bring on record whatever is required.
Yes.
Mr. H.K. Das, learned senior counsel, assisted by Mr. N.K. Sharma, learned counsel for the petition. Etu date to bodli jabune. Because yesterday I had, because I knew I had to upload this order today. So I recorded all your submissions yesterday itself.
We are grateful, Milord.
Be there. Also heard Mr. D.J. Das, learned CGC. Oh no, Miss L. Devi, learned counsel appearing for the respondents number 1, 4, 5 and 6. and Mr. D. Saikia, learned senior counsel, assisted by Dr. A. Chamua, learned counsel, appearing for the respondent number 2 and 3.
Lordship, I have objection for allowing him to file affidavit on the basis of my records now. That may be recorded.
Mr. Das, learned counsel, senior counsel, basing on the notings brought on record by the respondent, by the by the respondents in the National Institute of Design, wherein one of the grounds taken for rejection of the application of the petitioner for grant of NOC to pursue the PhD course was that the sparing of the petitioner from the institute at this juncture would be detrimental to the works of the institute. Mr. Das, in view of the said projection made in the notings brought on record, has submitted that the respondents in their affidavit have brought on record a RTI reply furnished to the petitioner, wherein instances of such permission being granted for pursuing higher courses of study were set out. Names of employees of the institute who were permitted to pursue higher courses of study were set out. He submits that amongst the persons so listed, there are around 7 persons who are holding single cadre posts like the petitioner, but who were spared without taking any plea as is now being taken in respect of the petition. He submits that an affidavit in this matter would be filed by Monday. Mr. Saikia, however, has submitted that the matter being taken up for final consideration, at the instance of the petitioner by projecting that the last date for taking admissions is on 24/7/2026, the present plea taken by the petitioner, foundation of which is not made either in the writ petition nor in the affidavit in reply filed, be not permitted by this court.
When the matter is substantially heard.
And also after the matter was substantially heard by this court yesterday, date to DDA. So, be that as it may, as the petitioner has raised a issue of discrimination, this court permits the petitioner to file an affidavit in the matter. However, such filing of affidavit would naturally also require the respondents to be granted adequate time to respond thereto. So accordingly, the petitioner is to file the affidavit invariably by 27/7/2026. How long will you take, Mr. Chamuma?
And my objection may be recorded here, Lordship.
That we have recorded. I've already recorded.
Regarding the affidavit, Lordship may not have recorded my objection.
Disputed, no? Key issue. All of you require. Filed by him. I've recorded your objection.
My objection?
Yes, that he objects. I have said that you object to him on the ground that this foundation is not there in the writ petition and in the affidavit in reply, And also after the matter was substantially heard by this court. 27, how long will you take to file your reply?
Let that affidavit come, then we'll tell the court. It will not be possible.
So I'll have
Because
to fi-
we have to dig, as Lordship has used that word, digging the records. So it will take time.
Lord,
It will take time, Lordship.
I only, Lordship has seen consent already NOC acceptance.
Mr.
I'm just,
They'll have
You
to
cannot
examine
put
that,
the
no?
gun on our head to file the affidavit now.
There is no point in putting.
Mr. Das, you can't have the cake and eat it
I am
also.
not saying so.
You
What
can't
I
have
am
that.
trying to submit before your lordships is that so far as giving them NOC is concerned, that fact has already been admitted.
But the background.
I understand. I'll file a 2 or 3 page of small affidavit that will not, my lord, that the word fallen from your lordships that you have to dig from 1950 onwards.
No, 2019, 2018.
They are to take details of only these 3 persons who are akin to me. I am not concerned with the others. Who are akin to me, who are pursuing PhD, I am placing details of only these 2 persons and my ground of Article 14. Not more than that, my lord. So it will not be,
It depends upon the affidavit, whatever he takes. On the basis of that, will take reasonable time, Lordship. Will not delay the laying.
27. You do one thing. You give the soft copy.
Yes.
To Mr. Chamua.
Yes.
By tomorrow.
The problem is that he is not getting leave. So he'll be able to come Saturday or Sunday. I can give it the soft copy by Saturday, my lord.
Okay, Monday. Then we give time to Mr. Chamua to respond till 30th. 30.
No, it will be too short, Lordship. Yes, we'll file application for extension of time if required.
On 30, we'll have the matter on 31st. Right?
Thursday. My lord, I
Monday,
can give a soft copy by Saturday, my lord. I'll do one thing, my lord. I'll try to make it.
Because Saturday, Sunday, the institute is closed now. Saturday, Sunday, the institute.
I need to get his signature, so that's.
No. Saturday, Sunday, the institute is closed. What will he do with that certificate? Soft copy, he can do nothing. He'll be able to do it on Monday only.
I'm sorry.
See, I'll have to balance both of you.
I'm sorry.
If you can come only on
I take back my words. I'm sorry.
So we have it on 31st.
Fine, my lord.
We note the submission of Ms. L. Devi that it is permissible to take admission.
Yes,
by paying a late fee. Okay. 31st. But if it goes beyond 31st, this court will not be there for.
No, lordship will finish up in 31st, my lord. Otherwise, my read also become infructuous, my lord.
I have seen that the petitioner can dictate the court to take the time. That is happening now.
Mr. Das Soikia, the only anxiety of this court
we
is
are
that
equally
any point
anxious.
should-
We are equally anxious till now.
Understand.
But now onwards, we are not anxious. We will play our normal game.
You are at liberty to do that.
Yes.
And see, once a plea is taken of violation of Article 14.
Very nice.
We give them an opportunity.
Yes.
Let
And the beneficiary of Article 14 is to him also.
Do you think this court cannot see beyond?
Yes, Lordship, because if I have to make my whole arguments, it will take 3 hours. Lordship will allow me that also.
Mr. Soikia, all of you are allowed your
to
the maximum.
To curtail court's wastage of time.
That is
Lordship,
what
I have prepared the written arguments.
Mr. Soikia, I have yesterday spent nearly 2 hours.
That is why, Lordship, I cut short my arguments yesterday, number 1, and we have prepared a written argument so that Lordship won't miss any of our submissions. I have submitted that also. Now I have to get a fresh written arguments on.
Mr. Das.
Yes,
this is not the way the litigation should go.
To go anywhere. We stop at what is there. We pass our orders.
Yes, ma'am. I leave it to your lordship.
We are passing our orders.
Absolutely, Lordship. This way, that way, Lordship.
Pass our orders. But I have heard the learned counsel for the parties and peruse the materials available on it. The facts leading to the Mr. Saik Das, you have you said. Leading to
delivering the judgment.
Leading to the
delivering the judgment.
No, I'm passing it. Finishing.
My colleague will be here because I'm in another court.
Oh, please.
Deeply.
Mr. Das, I don't think so. This will take us anywhere. Because Monday, if you do it, your writ petition will become infructuous because I'll have to accommodate the
My
respondents.
lord, may I just point out one aspect, my lord? I had a talk with the client also, my lord. They said that Tezpur University is not as rigid like, my lord, MBBS courses. This is a PhD course. They say few days here and there in joining the classes, it's fine. I'm only trying to save the client for taking admission, nothing else.
We
If
will
your
not
lordships-
permit you.
If your lordships
We will not permit you until and unless we are confident, because
I'm
that
not
issue is
saying-
not before us.
I am not saying your lordship will pass that order. Since MS Devi has come up with an instruction that with a late fine it can be given, my lord. Lordship will fix a reasonable time so that I can
The
take it.
reasonable time is a time which they will have to say.
That is,
I'll have to provide for that.
I understand, my lord. What I'm praying for is before your lordships is that I'll file a very small 2-3 page affidavit.
It's not the question of your affidavit
Lord,
being small or
Let
big.
me deprived of my right to respond. Because
Mr.
I'm
Das,
not-
you have responded by way of filing an reply.
So we kindly appreciate the note sheet. It has been. my lord,
Okay,
passed-
you file and reply to that affidavit.
Yes, my lord.
My lord, may listen to her, my lord, she's. Not beyond 20.
Not beyond that.
Not beyond 20.
In those situations, the Supreme Court used a
We can't wait for that.
At least admission, my lord. At least I will be permitted to take admission, my lord.
We'll have to be satisfied, Mr. Das. We are not satisfied
You will take up on 27. I'll file my reply
to that affidavit.
to that affidavit. Lordship will have a prima facie satisfaction regarding this, my lord.
But then I'll have to give that point comes up now.
No, that's why I'm saying.
Then Mr. Das, Mr. Soikia on instruction submits that he requires 2 weeks.
No. My lord, respondent side will make submission, petitioner side will make submission, my lord. Lordship will see whether I have been able to make out a prima facie case or not before your lordship.
We'll stick to this material.
If I have been able to.
Because if I pass this order, you have an opportunity of appeal, at least before 28th. 28th is the last.
Lordship will kindly take up the matter on 27. At least Lordship will consider my prayer to file a reply to this on 27. Lordship will fix the matter on 27, my lord.
Okay.
That is my humble prayer.
That much submits that. Mr. H.K. Das submits that an affidavit has been filed by the respondents today. He prays that the matter be taken up on 27 so as to enable him to file, enable the petitioner to file a response thereto. Prayer accepted. Registry to list this matter again on 27. So, as Mr. L. Devi has submitted that the admissions would be permissible to be taken by the petitioner only till 28/7/2026. So, the matter would be heard at length on matter. No further adjournment in the matter would be granted after 27. Now, if I don't grant adjournment after 27, how will he file an affidavit?
I'll leave it to the God, my lord. I'll leave it to the God. Lordship will fix the matter. My humble prayer, 27.
I am before
Yes,
my
but
lord. I am not before God here.
I'm beyond the, my lord.
Deeply
Have your satisfaction?
Yes.
But
one food
I don't
for
think
thought,
so. This is going to take us anywhere.
But one food for thought from the note sheet to the respondents. Lordship will kindly take the note.
You tell me.
No, Lordship has to see. Lordship has seen. In view of the above, it is proposed.
Which is the note you're reading?
The most important note, my lord, the respondents are placing. In view of above, it is proposed. Lordship seen 2. Then not has been superimposed. For the first time in my thing, I have seen my instruction is that.
Read the whole note. The note.
I'm not on that. Even after writing the history, my lord, the conclusion defines the thing. In orders also, so many things said against us.
Today it happened to me. I had dictated whole thing, dismissed the repeat. My whole conclusion was dismissed. Finally, it was.
Conclusion.
Finally, it was would warrant acceptance of this court. The note was missing. I signed it. Then somehow it was there. Then I put a note there.
My
Will
submission.
not give it
No,
much
Milord,
credence.
this type of mistakes doesn't happen in.
Mr.
I'm
Das,
sorry, Milord, I'm
Mr.
sorry.
Das, the matter is over.
Fine,
27.
I'm sorry, I'm sorry. I'm
But
sorry.
Mr. Das, you're missing the bus.
My lord, my
Milord,
friend has not.
I can only appreciate
20?
28-7 with late.
28-7 with late fine.
my savior is only the God.
The interim order passed earlier to continue till the next date of this.
Deeply obliged.
By slip. আরো কি না আগুয়ে যাও। Mr. Chaudhary, what are you waiting for?
There is one matter,
Hmm.
the hearing matter, my lord, it take some time. 37.
Which one?
37. 36 only. 36. Look at it, more nine.
For the respondent.
36. Connected matters.
36, item number 36 was filed challenging the order of penalty and 37 appellate authorities.
Anyway, everything merges in 37.
That is, oh yes, yes. Dismissal from service.
Yes.
This is to do with some that there was a CBI case here.
Yes. That trial is going on.
No. So those
Trial has not come
evidences
to an
were
end.
considered here.
Lord?
That material was considered here.
Yes. Yes.
And the author of those materials or who had procured that
Well,
material.
on several counts, we are challenging the first, my lord. The appointing authority is not the disciplining authority here, number one. Number two, we'll try to persuade your lordships to take the view that it's a case of no evidence.
Because that legally, the evidences coming on record cannot
my
be
lord,
held to be legally.
And number three, most importantly, the complainant, who my lord gave his evidence, he
Is
never
not
appeared for cross.
admissible. But that evidence was taken.
Taken
not
note.
proper. Yes, Mr. Chakraborty.
My lord, basically they have.
No, but this will have to have
They-
a hearing. It
Yes,
cannot
it
be
will
done.
take some time.
It will take some time.
Give me a date, we'll have it.
Lord, can it be on the first week?
Any day, give me a date. Comfortable to Mr.
Let us
Chakraborty
agree
also.
to a date. 7th, my lord.
Seventh
But
is a Friday. Seventh is a
The Learned
Friday.
Council for the parties have submitted that the pleadings in the matter is complete and the matter can be taken up for final consideration. As agreed to by the Learned Council for the parties, Mr. Chaudhary, don't put it on 7, it's a Friday.
Okay, some other day.
6.
Okay. So there is a-
Sorry.
Oh, yes, yes, yes.
6.
Because
My lord.
7 again, the
It's
miscellaneous
Friday.
matters. 7, 8.
My lord,
6.
in that case, 6th, I have some difficulties. Let it be on 12th. 12th,
Okay, okay.
11.
13th.
No, 13. Wait, 13, go there. We'll have it on 11.
11.
11, 8.
11.
11, 8.
So, my lord, I'm
For
representing,
admission hearing. Duta ekalage might be.
not for admission, my lord, for final hearing.
For hearing.
Today it has come up in hearing.
Hearing, sorry. Somehow.
Well, I'm representing ONGC in both the matters.
You have said heard the Learned Council. You want your name to be recorded.
Material
Like
instruction.
Mr. K.N. Chaudhary, Learned Senior Counsel for the petitioner. Learned Senior Counsel assisted by Mr. B. Purkaisto, Learned Counsel for the petitioner, and Mr. S. Chakraborty, Learned Standing Counsel, IOC.
Not
Oil-
standing counsel,
Uh,
counsel representing ONGC.
Council representing the
ONGC.
authorities. Also, as it is submitted that the pleadings are complete, and the as agreed to by the Learned Council for the parties, registry to list this matter again, pleading complete now again. Registry to list this matter again on, when did we give the date?
11th of August.
11/8/2026.
Finally, peruse the order dated 13/7, my lord. A pension proposal has been submitted before the Director of Pension, my lord. Therefore, my lord, this honorable court, my lord, directed to.
Yes, Mr. Soikia, what has happened?
My lord, my instruction is that, my lord, initially they submitted a proposal. Then some deficiency was there, therefore it sent to the Zilla Paripad again, my lord. Thereafter, my
When
lord,
have you sent it?
my lord, last communication, my lord, on 17/11/25, my lord.
You have, it came on 4/9/25. It's wrongly recorded as
My lord,
4/9/26.
Same,
Wrongly.
my lord.
It is 4/9/25.
My lord.
And you send it back on 11?
17/11/2025.
7?
11/2025.
Mr. Huddy, learned counsel for the parties. Mr. P. Saikia, learned counsel for the learned counsel appearing on behalf of appearing for learned government advocate appearing for the director of pension. On instructions I have submitted that the pension proposal of the petitioner received on submitted to the directorate while a communication dated 4/9/2025 on being processing, comma, certain deficiencies having been noticed therein, comma, the said proposal was remitted back to the Chief Executive Officer, Jilla Parishad, Baksa Jilla
No, my lord,
Parishad.
Kamrup, my lord. Kamrup Jilla.
It has gone to Baksa.
My lord, his residence, my lord, Baksha.
Chief Executive Officer, Jilla Parishad, Baksa.
Then, my lord, it is wrongly, my lord. He is the, my lord, employee of under Kamrup.
Ah. Yes, you have sent it to the wrong authority.
My lord. The secretary is GP, Rajapara GP under Payani Development Block, Kamrup Jilla.
It's sent to the Baksa.
Has been remanded back to the Chief Executive Officer, Jilla Parishad, Baksa. So, this court finds that the petitioner was an employee working under the Chief Executive Officer, Kamrup Jilla Parishad, and accordingly, it is not revealed as to why the Director of Pension had remanded back the pension proposal of the petitioner, which was placed by the authorities of the Jilla Parishad, Kamrup Jilla Parishad to the Baksa, authorities of the Baksa Jilla Parishad. The Director of Pensions shall take remedial action in the matter and place the proposal before the authorities of the Kamrup Jilla Parishad within a period of 2 weeks from today. So thereafter, the authorities of the Jilla Parishad shall rectify the deficiency pointed out in the pension proposal prepared in respect of the petitioner and resubmit the same to the Director of Pension Assam within a further period of 3 weeks. So on receipt of such pension proposal by the Directorate of Pension Assam, the same shall be expeditiously processed. So, 2 hafta, 4 hafta. Registered to list this matter again. On the next date of listing, Mr. P. Soikia and Mr. A.K. Ghosh, learned, Mr. P. Soikia, Government Advocate, and Mr. A.K. Ghosh, learned, Standing Counsel, Panchayat and Rural Development Department, shall apprise this court as to the further developments taking place in pursuance to the directions passed herein above in the present order. Registered to list this matter again on 24/8/2026. So you have sent it to the wrong authority.
My lord. And one copy marked to the, my lord, commissioner also, my lord. One copy marked to the Joint Commissioner Office also.
We don't know, but
Address
the
to the-
proposal, if it goes to some other authority, again, it will be delayed
My lord,
unnecessarily. So get it.
I'll communicate correctly.
Oblige.
Mass oblige.
Item 35.
May I please?
What happened to 812? It's pending.
I'm sorry?
812, WBC 812.
No, well, that is withdrawn.
It's based on 7/12/2022.
Page 64 of the repetition, the withdrawal order.
Yes, what is your case?
Yes, sir. Who is challenging the selection process, my lord? Yeah.
We'll have to hear it finally, right?
Yes, it is listed for hearing. My lord.
No, but today it's not possible. This is an advertisement of 2018.
2018. May I submit one thing, my lord? I think it is a res judicata, but the same cause of action, if file and one writ petition, this is a sixth round of litigation.
Okay, where is that last order? That order directing you to be granted some benefits?
Order saying, my lord, one post should not be filled up.
No. Honorary service.
Yes.
What is your case? What is your grievance?
No, we are challenging the selection process, my lord. The first thing, my lord, there was an order in 812.
You have made all the parties of the response?
Yes.
Yes. So post is grateful.
Grateful, my lord.
Advertised.
10 posts.
You come up before this court. This court says that that period of service should be taken into
consideration.
So what was how many marks did you get in the selection process?
I'll come to it, my lord.
You tell me that.
Firstly, they say I get 52 out of 50. Then they have annexed some documents in their affidavit in reply, my lord. They are saying I get 46.
46. What is the cutoff marks? You are general.
General.
How many posts for general?
Yeah.
Out of the 10?
If I may. Page 43, my lord, the advertisement, my lord. 10 numbers, unreserved 8.
So what is the cutoff for unreserved?
That I will not be
Above
able
60
to
marks.
So 46 you are not disputing.
No.
46 you are comfortable. What is the last mark scored by a male candidate recruited against the post against UR quota? Last candidate.
In the selection list, marks are not there, my lord.
What is the cutoff marks, mister?
What?
Who is appearing for the private respondents?
Oh, I am appealing for the government, my lord.
Private respondents?
That
So you are also appearing for the general candidates? What is the cutoff marks? Mr. Munir, what is the cutoff marks?
That I will not be able
So if we have to give you, say, some marks, if it's still below the cutoff marks, what is the point in pursuing the matter?
that I agree, my lord. In their affidavit, my lord, they have annexed some marks. If my lord, if I may take your lordship to
No,
page
show me.
Lordship, kindly see
84,
our
my-
affidavit page 76, my lord.
if I may complete, my lord,
Auto mark is there.
86, huh?
84.
Hmm.
That is the marks given to a examination center held in Bengali High School, my lord. My lord, you kindly see 84, the first eight.
Okay, we'll consider this. There are some other matters which may have to be considered today. As agreed to by the Learned Council for the parties, registry to list this matter again on 6/8/2026. For hearing. 6/8.
6th of August.
August.
Otherwise, there is a written argument also, my lord, we have prepared it.
Yes, Mr. Chaudhary.
With your lordship.
Hmm.
One of the petitioner before lordship is an SS officer. There were two proceedings against her. And both the proceedings have come to an end. And eventually, my lord, he was reinstated. Her claim in this petition is that pursuant to setting aside of the orders of penalty, she should have been considered for promotion when her best match were also, my lord, considered. And that is the only prayer before your lordship, my lord. In the
What
meantime,
did they do?
my lord,
What did they do? Your case was kept in seal cover.
yes,
Was kept in seal cover.
yes,
Then the penalty came. So there was no point in opening the seal cover. Thereafter, you challenged that. This court dismissed, this court allowed the challenge
yes.
and granted you
All the
reinstatement
benefits.
and all with all consequential penalties. Then what happened?
Then, my lord, your lordship will find after the order which was passed by this honorable court at page 50, my lord, where all the penalty was set aside with all consequential benefits, then she filed a representation that is at my lord page 59, claiming all the benefits including promotion. Now, my lord, what happened? The review selection board met.
Oh,
If your lordship comes to page 67.
he is already retired.
Yes, ma'am. In the meantime, she has retired, my lord. Now, if you
So you are claiming promotion to what? Which post?
promotion selection grade 2, my lord.
Selection grade?
2 of the SES.
When were your juniors promoted or your batchmates promoted?
My lord, my batchmates were promoted on my lord, senior grade 1, they were promoted on 17/5/2001. SES grade 2, my lord, they were promoted in 2020.
Selection grade 2.
My lord, for senior grade.
No, what are you? What were you?
I was my lord, junior grade SS officer.
When the proceedings were started against you, you were a junior grade.
Yes, ma'am.
So you retired as a junior grade.
No, my lord. In the meantime, I have been given a promotion. That is on my lord 2000. On my lord 22/1/2020 to SS senior grade 2. That your lordship will find at page 93.
Now, when were proceedings instituted? You were first promoted from junior grade when?
Promoted as from junior grade to senior grade 2 on 22/1/2020, my lord.
22/1/2020. When were proceedings instituted against you?
My lord, proceedings were initiated. My lord, first DP was my lord initiated on 12/11/2015 at page 44.
So, first DP 12/11.
My lord, 12/11/2015.
2015. When was this closed?
And the first DP and the other DP in the my lord, first DP, the penalty was imposed on 7/10/2017.
7/10/2017 penalty. Okay, what was the penalty?
Penalty of, my lord, stoppage of 3 increments with cumulative effect, and, my lord, period of suspension treated as on duty only for the purpose of promotion.
So you challenged this. This was challenged.
Yes, my lord.
Then what happened?
The order of this honorable court, your worship will find at page 50.
50.
My lord, I have another point to argue, my lord. Both these disciplinary proceedings were in respect of the, my lord, same incident.
So when was the second one?
1 DP, my lord, on 27/4/2014.
So the first DP is 12/11/2015, second DP 27/4/2014.
Yes, my lord. That should be the first thing. In fact.
First one, huh?
27/5/2014.
27/5.
My lord.
Now, what is the penalty here?
That is, my lord, it was imposed, my lord, that is stoppage of 3 increments with cumulative effect, my lord. That is the penalty.
Same penalty in both the cases.
Not same penalty, my lord.
When was this second penalty issued?
First DP, my lord. First DP was decided later. It was, my lord, censured no pay during the period of absence from 11 to 2014.
So was this both the penalties? When was that penalty, second penalty issued?
Second penalty for my lord,
2014.
Huh?
Second penalty, my lord, 12/11/2015 pass order, final order.
First one 12/11, fine.
Yes, my lord, imposing major penalty of stoppage of 3.
When was that penalty issued?
Penalty issue at, my lord, 12/11/2015. Right? And first.
Yes, that is the penalty, yes.
First penalty what that order passed on 27 May
So,
2014.
Mr. Chaudhary, both the penalties were interfered with by this court.
Yeah,
No,
in fact, my lord, in the first appeal, where, my lord, the period of absence should be treated as on duty, that, my lord, on appeal, that was allowed, my lord.
Which one?
The
Censure was removed.
Yes, yes.
So
Effectively, my lord, there is one penalty which has been set aside by this honorable.
so when are you now? Which is the date you are claiming your promotion from?
My promotion, I want, my lord, I was promoted to SS Senior Grade 2 in 2020. But my batchmates were promoted in 2015, when, my lord,
You were under cloud.
yes. And eventually, my lord, the second, the promotion to Senior Grade 1 also, my.
Okay. Yes, Mr. Choudhary, what do you say?
So my lord, submission is there, my lord. First DP, my lord, final order passed on 7 October 2017, imposing censure. That is continuing. And second, my lord, DP one
Censure, Mr. Chaudhary says on appeal it was removed.
censure. My lord, affidavit does not say like that, my lord. I am reading the affidavit, my lord, paragraph, my lord, lordship, kindly see our affidavit.
Okay, I think some factual matrix has to be,
Yes.
we'll have it on our
I'll
different.
prepare a list of dates and that will convene to your worship.
On the prayer as agreed to by the Lanaka councils for the petition, for the parties registered to list this matter again on 11/8/2026.
For further hearing.
For further hearing.
Come, it's,
That is it for further hearing.
I'm not here, that's the problem. I'll not be here for the
Distance
whole
hearing.
next 2 weeks.
After 2 weeks, my.
On 28/2026 for further hearing.
Obliged.
Yesterday somehow this file did not, I don't know what happened, maybe I could not read it.
My lord, regarding 40 item, my lord, I have received the record back. But I have not completely read out the records. Only last occasion, my lord, I was directed to obtain instruction, whereas second notice, my lord, inquiry report was furnished to him or not. My lord, I found here, but inquiry report was furnished to him, but that is. So, my lord, entire records, my lord, I have not gone through it. Inquiry report was not furnished apparently on the face. That's our whole case. Now,
There was a notice before
36
passing the order, was a
30
notice
30
given to you?
no notice was served. If you see the order of 36, 2025, see the order of 36, 2025. Please see 36 at page 35. That's my only case. The inquiry report was not furnished.
Of the writ petition, page
Yeah,
35.
yes, the inquiry report was not furnished. Inquiry conducted, presenting officer whether inquiry completed, report. Please see. Anu, so and so district jail Moriga have been serving as so and so, so and so. Now please see number third. Whereas as a part of departmental proceedings, Superintendent Special Jail Nagaon was appointed the inquiry officer by the office dated 24/2000 to inquire into detail about the incident. And he submitted inquiry report by his letter dated 10/4/2000, wherein it was established Anupar Malakar Warden District Jail is found to have displayed gross neglect discharging, which led to the incident of escape of 5 dreaded under criminal. As such, charge violation of so and so has been established. After disposal of department without prejudice, as per so and so is hereby removed from service so and so. Now I will show more. Please see the affidavit. Please see the affidavit that the state has filed. Please see, my lord, page 55. And please see the order, impugn order at page 35. Please keep one and the order of 35. One and the order of 35, another page 55. Please see the memo number, my lord, at page 35. Impugn memo number, page 35, before seeing the affidavit. Please see the impugn memo number at page 35 on the top, left-hand side, at page 35 of the writ petition. Lordship got it? This is our claim. I made, my specific reply is that you made it when I came to this. You made this.
Yes.
Cannot be
Mr.
15.
Give me the records.
See this. That's
Show
our
the,
claim.
show the communication of the inquiry report.
That is, my lordship.
The one
this-
issue number which has been shown to be issued subsequently is 12. Whereas the earlier one issued is shown to be 15.
16 June 2025.
No, the issue number.
Issue number.
Issue number 12 and 16, 15. Just show me that. Give me the records. No prejudice to you. We'll cost this. Ask him
No,
to.
that's why it's a question. Sir,
Send back.
that goes back again, my
And the petitioner will deem to be under suspension. That's all.
lord. Yes.
My lord,
that's
crime is
that's
very
right.
heinous crime, my lord, lordship.
I know, all the claim.
Live UTPS, my lord, they are involved in the POCTO case, my lord. So they are.
Mister, that
away.
will not give you a license to do a departmental proceeding as per your own wish and
No, that
caprice.
is the following
that
due
is the
process of
problem.
law, but there is no irregularity in the process.
Now we should direct that the persons who are conducting the inquiry will also have to be brought within the.
No, we have already furnished the second show cause notice to the petitioner. my lord.
Show me that when it was served on him. Show me. Where is
Inquiry report. That is, my lord, that's why, my lord, I could not complete the records, my lord.
It is not.
But,
what is this records?
Well,
No
the
note sheet,
first
nothing.
one, no, first one is,
No note sheet is there. Note sheet is there.
note sheet is there, my lord. There is a direction to provide him to the, so page 55, our affidavit, that is the ballot inquiry report, forwarding report, 16 June 2025. This one, 15, now it will, 18 or this one. No, not this one, I don't know. But one is there, no, anyway. Give order. A memo number. One is 35, 35. It was available report to prove order. 25 June 12, or 1850. Yes, sir. It will 50 percent to go. Oh, it was a fee. It was like 8. That may be. You can have a look.
What is the date of that Inquiry, that forwarding of the inquiry report?
Forwarding of the inquiry report,
Huh?
This is 16th of June 2025. And number PR, your lordship get a number. Memo number. এটা তো 25 হচ্ছে না। 25
Who is the authority issuing the penalty?
Penalty
It's
is,
DIG.
yes, right.
Mr. Sutia, this much will do. There is no reference of your this issue number
Yes, sending the inquiry report to the petitioner.
petitioner.
The issue number is different.
So you now can't go beyond that date. That date is 16?
16 June 2025.
16 June 25.
2025.
So if that be so, 3 increments with cumulative effect. Penalty?
Penalty is dismissal for service. Removed. Removed from service.
Removed
from service. 30th June.
So what is this? This is some.
No, I will have to clarify it regarding this memo number, my lord.
What is the name of the petitioner?
Is Anup Kumar Malakar.
Mister, this is not the record.
Records is, this is the records, my lord. Another record is there, but he was earlier occasion also, my lord, there was the public proceeding against the petitioner, my lord. This one also, my lord. That's two records are there. His conduct of my lord in the service is not good. Earlier occasion also he was held guilty. One number of type to late. No. একটু ঠিকই আছে একটু বলতে লেগেছে
So cause is 29/1/2025.
Yes. 29/1/2025 for cause. There are only few dates, my lord, there are not much. 10/10/2024.
No, mister, just a moment. I'm just specifically looking for that letter. This is very haphazardly maintained records. Nothing is here. The documents are not here.
So if you, my lord, read the order of 30th of June 2025, where I was discharged from this service, terminated from service, when you see the third paragraph, my lord, if I read the third paragraph, apparently it appears that it was never served. Kindly see, whereas as a part of departmental proceeding, Superintendent Special Jail Nogam was appointed as
It's
inquiry.
okay, Mr. Das. Hut Mr. D. Das, learned, counsel appearing, assisted by Mr. M. Mohammed, learned counsel for the petition. Also heard Mr. T. C. Sudhia, learned senior counsel, appearing for the, assisted by Mr. B. Bikram. Huh? Bikoya, learned government advocate, appearing for the respondents. Mr. Das, learned senior counsel for the petitioner, has categorically submitted that before issuance of the order dated 36/2025, a copy of the inquiry report was never not furnished to the petitioner. He submits that although in the affidavit filed by the respondent, a communication dated
Page 55.
dated 16/6/2025 has been brought on record, and a perusal of the same would go to reveal that the petitioner was forwarded with a copy of the inquiry report. Mr. Das submits that there is no material brought on record to demonstrate that the said communication issued was served upon the petitioner. Mr. Das has further submitted that the issue number of the said communication dated 16/6/2025 is after the issue number given in the order dated 36/2025, although the said communication is stated to have been issued prior to the order dated 36/2025. Mr. T. C. Chutia, learned counsel for the learned senior counsel appearing for the respondents, shall submit shall on instructions received submit before the place before this court materials to demonstrate that the manner in which the communication dated 16/6/2025 was forwarded to the petitioner and as to whether the same was served upon him. Mr. Chutia shall also explain as to the discrepancy existing with regard to the discrepancy highlighted herein above by Mr. D. Das, learned senior counsel, with regard to the issue numbers assigned to the communication dated 16/6/2025 and the order dated 36/2025. Raisely to list this matter, how long will you take, Mr.?
2 weeks time,
2 weeks. Today is,
Today is 23.
on 11/8/2025.
11.
If that is so, the order will go.
Well, yes,
I don't get anything there.
This foreign letter is here, my lord, but I have not seen, my lord, whether it is communicated or not.
No, the forwarding letter is also not there.
That foreign letter is there, my lord, the record. This one.
Maybe I missed them.
And enclosed also, they have not enclosed the inquiry report also. As enclosed, they said they have not enclosed.
No, if the communication has been served on you, we will draw a presumption that you have got it.
No, that's different, my lord.
Because you have not responded by saying that you have only given me the forwarding, not the material.
No, I said that no inquiry report has been furnished to me.
So that
There's specific stand.
No, Mr. Das. If that
Yes, right.
if that communication is served on you, the presumption would be that the inquiry report was enclosed there too.
Yeah. Enclosed, well, close. We are No, that's true, my lord. The presumption will be drawn.
That document, that they'll have to show that the letter was served. That's all.
Right, yeah.
Yes. Time being. Yes, anything more to be submitted? Yes, Mr. Chaudhary, anything more to be submitted?
The last annexure of the writ petition It goes to show that actually he was dismissed from service. This is annexure 11, page number 47.
Where is that dismissal?
Yes, Lordship. That after completion of the tenure of ARTC such and such.
Where, we were?
Yes, investigating the seven with
Where
the.
are you reading?
This is a page, annexure 11, page number 47.
47 is
Yes.
something else.
Page number
It is
47, Lordship.
49, 25/3/2012.
No, Lordship, yes, 23 March 2012. The last paragraph, paragraph number 4. I therefore taking into consideration the entire circumstances of the case, I have the considered opinion that further retention of such and such name Mohabit Thapa is not warranted. I therefore virtue of powers vested in the under section 4(1) of the Assam Rifles Act such and such dismissed from service with effect from 8 February 2006.
This is 25/3/2012. Now you come to
Yes, Lordship.
your affidavit.
Yes.
Para 8, page 53.
Yes. Yes.
So how can you say that it was dismissed? You say it's an error.
Lordship.
You yourself say it is an error.
Due to oversight as issuance of dismissal order in respect of a deserter already dead was not proper. So that observation is there. I am stating about the fact that this order was issued. This order was issued on 2012. With regard to the fact that since the observation at paragraph number 6 was there in the affidavit, we have made a mention that he was kept on supernumerary strength for 5 years as per policy of a deserter keeps land. So in that view of the matter, he was 5 years was not taken into consideration. After completion of 5 years, he was dismissed.
So what is the effect of this order?
This order.
What effect does this order have? Why are you making that submission? I'm not getting it. That's why I'm asking.
No, I'm submitting because of the fact that there was some dismissal order, rightly, wrongly, that has been passed. Subsequently, we have clarified in our paragraph 8 of the affidavit in opposition that this.
So no, tell me one line.
Yes.
What is the effect of this order on the petitioner's claim?
So this order, because we have already narrated in paragraph 8.
So why are you referring to
Yes.
that? Unnecessary.
Only thing is that.
Council for day. We are allowing the whole thing. We are granting.
Up to 2007,
to that lady.
After 2007. Because since 2007.
No, it will be till 2009 because that you have not determined as to whether the first petitioner or the husband of the petitioner was prevented from joining the duty. You have not determined that.
No, even this is not
willful.
No, even this is not the case of the writ petitioner also. He was.
It's my case. We are giving a poor lady would not be made to suffer like this. Counsel for the parties at length. Here, hearing remains inconclusive. Register to list this matter again on 28/7/2026 for further hearing. I'll pass the order on that day.
Lordship, in item number 41, Lordship, I have received the instruction. Can it be taken after 2 weeks?
We are reaching.
Yes.
Let us read the first.
Kindly have a look at the last order.
Yes, Mr. Adolfo, what has happened?
4/6/2000.
Anything done?
No, my lord, I've got the instruction. My lord, they can fall back to regulation 44, my lord.
This why this is not given to him?
My lord, they were in the impression that conviction cannot be stayed, my lord. Conviction was not stayed, a suspension of the sentence.
No, the order is that the entire thing is stayed.
But it is MP order stayed, my lord. In fact, my lord.
That is different, Mister. But what order? We understand.
Yes.
Normally, a sentence is only stayed.
Yes.
Is that order of this court?
Yeah, that your lordship will find at page. My lord, 61, my lord. The last para.
Here, everything is stayed.
Yes, yes, impugn order is stayed.
So once it is stayed.
No, I'm not arguing on that.
No, no,
but I'm just.
once it is stayed, he cannot be held to be a convicted employee as on.
Your lordship is
proceeding
very
pending.
correct, very correct.
So you give him the benefit
Yes,
under,
yes, that is what I'm saying.
we'll dispose of the matter.
Yes, yes, this is the only issue here.
Heard Mr. Doctor, what is your full name?
K. Burwa, my lord.
Huh? K.
K. Burwa, my lord.
K. Burwa, learned counsel for the petitioner. Also heard Mr. S. Dr. learned senior counsel assisted by Mr. S. Shaw, learned counsel for the respondents. The petitioner in the present petition has prayed for a direction upon the respondent authorities for authorizing to him his pension and other pensionary benefits for the services rendered by him with the said authority.
Your lordship, I'm sorry to interfere. Your lordship will find there is an order of recovery of 1,64,000. So that part of the thing.
So
It was recovered.
So, heard the learned counsel for the parties at length. At some length, hearing remains inconclusive. Registry to list this matter again on 30/7/2026 for further hearing. I'll pass the orders on that. There is a penalty also imposed, three increments down.
Lordship.
Yes, yes.
3 increments down along with the recovery. That will be
Right.
permissible to you.
Yes, yes. It's coming on 37.
30. You need not be, I'll pass that order. Only thing, with regard to that pension, minimum of what is to be given.
Right. All right.
And I'll just examine whether the recovery can be made.
My lord. Obliged.
Recovery already made, my lord.
Huh?
Recovery
Already made.
Already made.
If it is so, my lord, your lordship can pass the order. Subject-
Just go through it once.
Subject to the condition that it is already
Recovery is already
Made, my lord.
disposed of. Korea.
obliged.
Disposed of.
Like.
21.
Yes, Mr.
My lord,
Question.
my lord, here, my lord, my simple prayer is, my lord, the record may be called for.
Wait.
Why, my lord, I'm placing that, my lord. As per their affidavit, my lord, total posts were 14. I need to pass.
Now show me the pleading in the pleading with regard to that argument.
My lord, what happened, my lord? Kindly consider one thing.
You are for the post of physics.
My lord,
You are for the post of.
for the post of physics.
Hmm.
And my lord, they are applying that notification regarding local area in pick and choose manner.
We will deprecate that.
No. My lord, imposing cost will not do. It will be not enough. Why, my lord? Kindly come to their
Yes, Ms.
affidavit.
Bhuyan, last date we required you to take what happened. What has happened?
I've sent some telephonic message to them, my lord.
Hmm.
They have given some instruction. That's perfectly nice. The clarifications given by the college. And what is the locus, my lord, of the writ petitioner? Unqualified candidate, my lord. Lordship, the question of preference will come.
Okay. Yes, Mr.
My lord, kindly come to the affidavit filed by the respondent number 5 and 6
Hmm.
at page 85,
Hmm.
paragraph 17.
Hmm.
Here, my lord, in the writ petition, we have placed one example
Hmm.
that the chemistry candidate,
Page.
page
Page
85.
85.
The candidate of chemistry.
Para?
There are 70. My lord, kindly, from bottom, last 3 lines. But the respondent denied the challenge of the petitioner that Dr. Korobi Roy was selected only because she is from the BTC area, whereas she got marks, overall marks of 70.50 in the interview with a neck-to-neck competition with negligible difference of marks then other
What
highest
is
mark
the
getter.
difference of marks between you and the other selected candidate?
My lord, I will come to that, my lord. Kindly,
I have read it because
my
this is
lord-
the same thing which the instructions.
my lord, kindly then come to paragraph, page 207, annexure 6.
I think you will ask your junior to remark the page numbers. There is some difference in the page.
My lord, this is the.
Okay, this
my-
is what is this?
This is
RTI.
the annexure 6 of the, of the affidavit in opposition by the respondent number 5 and 6. That is the resolution, my lord.
There are 2-3 numbers here.
Annexure 6, my lord.
No, there is a difference in the numbers, Mr.
My lord.
It's just 6.
My lord, only thing, my lord, as per this resolution, I made that chart.
207. It is now 237. Yes.
237. These are the 5 resolutions.
How much marks did you get in physics?
Physics, I got 53 or 56, like that, my lord. I have to check, my lord. Kindly come to resolution number 2.
Korobira.
Korobi 70.50. And kindly see vis-a-vis the mark sheet, my lord. They have produced that. Which is at page
210.
here, my lord, in my pagination, 229.
Mr. B. G. Bush, Learned Council, also heard Ms. S. Bhuyan, Learned Senior Council and Standing Council, Bodoland Territorial Council, assisted by Ms. B. Kashyap, Learned Council, assisted by Ms. B. Kashyap, Learned.
P. Kashyap,
P.
Punjab.
P.
And I'm Bombay, man.
B. Kashyap, B. Bhuyan. I dare not. Also heard Mr. U. Soikia, Learned Council, appearing for the correspondence number 7. During the course of the deliberations, it was found that there is a mismatch in the pagination of the briefs of the Learned Council for the parties and the brief of the records of the present case. Accordingly, Mr. Bush submits that he be given a week's time to rectify to properly paginate his records. Prayer accepted. Registry to list this matter again on 31/8/2026. Any problem on 31/8/2026 as a part heard matter? See, I'm not able to. Last time also we found it, but somehow we could. But this short time, I'm not.
Already, because earlier this case is already it was fixed for the survey, but due to some
Mr. Bosho, Ms. Bhuyan wanted to argue, so I had to release it. I was about to dismiss it.
But I am the secretary.
So what to do? What do you want?
So,
Interim order we are not touching today. What's the alternative plan?
if it was, finally, then, on that,
The 31st December, 29 Korea. At 2 p.m.
so you're not.
30th, declare, yes, sir.
2 p.m. Mr. Bosho, 31st, 2 p.m.
My lord,
You ask your junior to just
my
get
lord,
the,
my lord.
the records.
My only thing is, my lord, kindly consider for more than 40% 40% of persons candidate were appointed as BTR candidate. That's why.
You are unfortunate.
No, that's why my prayer is, my lord, that let the record may be called for. My lord, why, my lord? If it is
You
a,
show me a decision, Mr. Bush,
my lord,
that an illegality, admitted illegality is permissible to be perpetuated by this court.
my lord,
My order is with you.
my lord, kindly consider one thing. If it is systematic malpractice, which is amounts to fraud, your lordship will, as per the Supreme Court judgment,
We
your
will
lordship.
reject your case. We will not. If that be so, show me a decision that this court has power to pass orders against persons who are not before this court.
Yes, my
We
lord.
will pass orders, we will
Yes,
reject
my lord.
your application and also
my lord,
cancel their appointment. Show me a decision.
yes, my lord. 1993 Supreme Court, my lord. I
Just show me.
place that, my lord.
You just give me.
Yes, my lord. Law is very settled, my lord.
Then
Which is,
at least that sadistic pleasure will be there with the petition.
my lord, what happened, my lord? One single affair, entire APSC selection has gone, my lord. One single affair, my lord. One
have
single
filed an FIR
incident
months
is
before, Mr.
sufficient, my lord.
You could have filed it in.
My lord, my lord.
We'll see.
Obliged.
Give me that decision.
My lord.
Hmm? No. 31st July.
I apologize, my lord. I was.
Mr. Have you got any?
But I have got the instruction, my lord. I was told that this order, my lord, of the appellate authority, which my learned friend has produced, that is of the year 2020, and somehow or the other it has been brought to the notice of the bank in 2025. Now, far beyond the prescribed period for any appeal, etc. whatsoever. Now, in this case, my lord, the order of the
We'll have to give it a consideration.
sometime.
As agreed to by the Learning Council for the parties, Mr. What was today, it will not be possible. Registry to list this matter again on 28. This is a further hearing. I've heard it. 28, 2026 for further hearing.
But can it be on some other date? 28 already.
28,
some other matters. 2008, some other date. Before or after?
18.
18.
So, my lord, the aspect that your lordship would see whether increments would be covered.
That
is the only extent of the issue, my lord, because they have forfeited the other bread, 1.5.
That you have given up.
I've given up.
Yes, what happened?
Lordship, I have received the instruction.
What is the instruction?
As per the instruction that I have received, here in this case, it has been mentioned that the concern, the husband of the petitioner, he had never informed with regard to this second marriage. And the communication that I have received in this, it has been mentioned that has never informed this office regarding the death of his first wife, late Asha Begum, subsequently regarding his second marriage during his service from 2006 to 2009. And even after retirement in the year 2009 to till his death, the entire matter comes to light only after the death of the pensioner and receipt of application for family pension from the petitioner Asma Begum on 19 April 2023. So in view of that, Lordship, certain communication on receipt of the requisite documents from the petitioner, the following actions have been taken. So we have issued certain letter to the birth and death.
Mr. S.P. Chaudhary, Learned Council for the Learned CGC appearing for the respondents have submitted that the husband of the petitioner, who was the government servant during his service period, had never intimated the respondent authorities about the solemnization of his marriage with the petitioner herein. He submits that after the death of the government servant, pension was being authorized Two, nobody, Fosa. It is submitted that it is only after the death of the government servant that the petitioner had approached the authorities praying for authorization of family pension to her. He submits that the documents on being received from the petitioner, the same are being now verified. He submits that the said process of verification would take how many days?
At least 4 weeks, Lordship.
Would take a further period of 1 month. He submits that after the submits that on the next date of listing, he would receive instructions he would place the decision arrived at by the respondent authorities in the matter before this court.
Yes.
So, in view of the submissions of the learned counsel for the learned CGC appearing for the respondents, this court directs the registry to list this matter again on 24/8/2026. On the next date of listing, by the next date of listing, the respondents shall complete all requisite inquiries, as stated to be underway by the learned CGC appearing for the respondents, and place before this court the decision arrived at by them with regard to the entitlement of the petitioner for being authorized family pension. In the event the matter being of authorization of family pension and the petitioner being around, what is your age? And the petitioner being having projected that she has no other means of livelihood. So the respondent shall not fail to complete the inquiry involved, complete the process of verification involved, and take its decision in the matter. Registry to list this matter again on 24th. And if I don't get it this time, I'll have the people. If I'm there.
No, the issue is that, Lordship, we are just calling for all these documents from other authorities. We have to get all the papers from the other authorities.
You said 1 month. I've given you 1 month.
I have no issue with regard to that. But the thing is that all these papers.
Next day, don't come and say that you want further time. That much only.
But the difficulty is that we are waiting for all the communications. If we don't receive the communication, it will be difficult for the authorities to take a call.
What communication are you?
Because this from the letter issued, we have already done all these things. Letter issued to the Register of Birth and Death, Kachar, for verification of death. Letter issued to Muslim Marriage Registrar and Kachigara for verification of the genuineness of the marriage. Lordship.
When did you issue?
That was on 18th August 2023.
23, you have not received.
Exactly, Lordship. All these papers
have we have got back to the petitioner saying that you have not got any response from this?
No, that has not been done. Lordship.
You have to do that. You have to do that.
Yes.
Lordship, we have already furnished all these
No,
documents.
no, they'll have to verify it. Your furnishing will not do.
Lordship.
Away to Marigan demo correction. Will 23 you have to, I'll reduce the verification is presently on. Mr. SP Chaudhary submits that. Yeah. He submits that although he submits that the process of verification is on. However, no response has been received from the authorities to which queries were sent by the respondent. Queries were sent. Full stop. He submits that the matter be taken up after 4 weeks, on which date he shall apprise this court about the further developments taking place in the matter.
Lordship, any fixed date, Lordship?
We give now date 24.
24. We'll do that, Lordship.
Now, Mr. Chaudhary has given us the actual date, 23. No response. What will the poor people do? They are left with no other alternative.
Great.
And your husband did not like you, maybe. That's why he did not.
Lordship.
Arun. Oh.
My lord, I already heard this matter.
I have to pass the order today. Everything. Arun, Due to paucity of time, the order could not be passed today. Raised it to list this matter again on 27th or 27th or it was. No? 28th. 7th. I'll pass the order before that.
My lord.
And next to
Obliged.
allowed. This is allowed. This is allowed. I'm disposing it off. You have dictated, you will get the order, but only on Monday, not before that.
Lordship is disposing it of.
I'm allowing your repetition. I am interfering with the penalty of 2 increments. Not happy.
No, I'm happy, more than happy. Like,